Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are talking a little bit about gambling in light of recent events that have occurred on Twitch. For those of you who have been watching, and for those of you who are not so aware, the Twitch has been going through some problems relating to gambling and sites that are not necessarily acting in accordance with law, and sites that are trying to skirt around the edges of what legally is or is not gambling. And this ultimately resulted in at least one streamer allegedly stealing about $300,000 in a scheme that has been a big issue over on Twitch, to the point that Twitch recently announced a terms of service change that prevents streamers from using certain sites that engage in things that could be viewed as gambling depending on how you're defining your terms. But at least on Twitch, this is no longer permitted because of issues like that. So I thought, in the spirit of this recent controversy that was occurring on Twitch, as part of our Great Cases series, we would go back and discuss one case that was dealing with gambling, a foundational case in U.S. law that helps to establish the power of Congress, in this case, to regulate gaming and regulate what is and is not gaming between the states. And even perhaps more importantly, in a lot of ways, regulate commerce between the states, because of course that's what Congress's power is, the power to regulate commerce under the Constitution, interstate commerce, and what that does or does not allow for. So Congress passed a law that prohibited, among other things, people transporting lottery tickets from one state to another state. So you could have lottery tickets within a state, but you couldn't transport them into a different state. And an individual was transporting lottery tickets as they happen to be Paraguayan lottery tickets. I'm not sure why Paraguay was all the rage, but they were. There was a Texas individual who was transporting Paraguayan lottery tickets from Texas to California, and he was arrested and charged with violation of this act. And his argument was, well, Congress can't do this. Why? Well, because Congress, according to the Constitution, has the power to regulate interstate commerce. And so his argument was, well, this is not the regulation of interstate commerce. This is forbidding interstate commerce. This is Congress saying a particular kind of commerce is not legal. They aren't saying, they aren't establishing, for example, uniform weight and measures. They aren't saying, well, here's how much a pound is going to be in terms of weight as between states, regulating that. They aren't trying to establish the mechanisms for how goods are going to be transported. Rather than simply saying that a particular kind of good, in this case, lottery tickets, as it happened to be foreign lottery tickets, but whatever, could not be transported between state and state. And that also, of course, extends beyond lottery tickets. It extends to all kinds of commerce. It's one of the reasons, for example, that marijuana remains illegal on the federal level. Why does the federal government have the power to prohibit people from transporting marijuana from one state to another state? Why do they have the power to regulate that commerce by forbidding the commerce? And this is one of the cases that establishes that. It's a foundational case that would later, of course, be extended by such wonderful cases as we've discussed in this channel, such as Wickard v. Filburn, but this is before Wickard v. Filburn. This is like 30 years before Wickard v. Filburn, and deals with the interstate transportation of lottery tickets and, of course, by extension, other goods and services. Can Congress ban the interstate commerce, or do they just have the power to regulate? Great. So we're going to be discussing that case in detail. So this is on appeal from the Circuit Court of the United States for the Northern District of Illinois. The year is 1903. And we're going to discuss this foundational case as it deals with the federal government's ability to regulate interstate commerce and trade, in this case, lottery tickets, but of course, by extension, any sort of good or service that would flow over state lines. So let's read this. The general question arising upon this appeal involves the constitutionality of a first section of an act of Congress of 1895, entitled An Act for Suppression of Lottery Traffic through National and Interstate Commerce and the Postal Service subject to the jurisdiction and laws of the United States. The appeal was from an order of the Circuit Court of the United States for the Northern District of Illinois dismissing a writ of habeas corpus sued out by an applicant of Champaign, who in his application complained that he was restrained of liberty by the Marshal of the United States in violation of the Constitution. Let me readjust the margins. It's old school PDF, so the margins are not perfect, so we'll just make do and have to readjust as we go. I appreciate your patience. In 1903, they hadn't yet perfected PDF technology. It appears the accused was under indictment in the District Court of the United States for the Northern District of Texas for conspiracy under the revised statutes, which forbid that if two or more persons conspire either to commit any offense against the United States or defraud the United States in any manner or for any purpose, and one or more such parties do not act to effect the object of the conspiracy, all parties to such conspiracy shall be liable of a penalty of not less than $1,000 and not more than $10,000 and due imprisonment of not 10 years. So, as is true in modern law, all members of a conspiracy are equally guilty to all other members of a conspiracy. It's one of the main reasons that you should not join conspiracies, because you don't even necessarily need to be aware of what the other members of the conspiracy are doing. The right hand does not need to know what the left hand is doing, as they say. When you enter into a conspiracy, you enter into it for a criminal purpose. If one member of the conspiracy commits acts in furtherance of the conspiracy, even if you don't know what those are, then you're liable anyway, as though you had done it yourself. So don't join conspiracies because you don't even know necessarily what you're going to be on the hook for. And so this person is being charged as part of a conspiracy, and so he's getting basically what everyone did as part of his penalties because he was part of the conspiracy. Don't do the conspiracies. He was arrested in Chicago under warrant, charging him with conspiracies with others in Dallas, in the Northern District of Texas, to commit the offenses. Not quite sure why he's in Illinois, but as I mentioned, the offense in question was shipping tickets from Texas to California. But he was arrested in Illinois. Okie doke. And the object of the arrest was to compel his appearance in the federal court in Texas to answer the indictment. We'd like to extradite him to Texas to answer for his crimes there. The first section of the act in 1895 upon which the indictment was based is follows. Okay, so here is what is illegal at the time. Any person who shall cause to be brought within the United States. All right, so now let's look at these terms, right? Within the United States from abroad, so bringing it in within national borders of the United States for the purpose of disposing of the same. So you are bringing them into the United States in order to give them away or something, as opposed to merely transporting them through the United States, right? You are disposing them within the United States, selling them, giving them away, whatever, right? They're ending their life in some sense in the United States as opposed to merely passing through. All right. Or deposited in or carried by the mails of the United States. So if it goes through anything that the Postal Service, we're going to ban that. Or carried from one state to another in the United States. So there's the interstate component of it. Any paper, certificate, or instrument purporting to be or representing a ticket, chance, share, or interest in deposit upon the event of a lottery. So it doesn't necessarily need to be a ticket. It just needs to purport to be a ticket, right? So this is also covering the possibility of it being a fraudulent ticket, right? So it doesn't need to actually be a genuine lottery ticket. It could just appear to be a lottery ticket. It could be a fraudulent ticket, or it could be a ticket for a lottery that doesn't exist, right? It doesn't need to be genuine. Anything that would look or behave like a lottery ticket or appear to be a lottery ticket will be fine for the purposes of this. So if you bring it in from outside the United States, you ship it through our mail, or you carry it between states, interstate, any paper, certificate, or instrument purporting to be a ticket, chance, share, or instrument dependent upon a lottery, so-called gift, concert, or similar enterprise. Again, just because we call it a gift, we're not that dumb, right? So if it's a lottery, we don't care that you call it a gift. We're not that stupid. If it's dependent upon a drawing, it's a lottery. offering prizes dependent upon lot or chance. That's kind of what a lottery is, right? Or shall cause any advertisement of such lottery, so-called gift concert, or similar enterprise, offering prizes dependent upon lot or chance, to be brought into the United States or deposited in or carried by the mails or transferred from one state to another, shall be punishable by not more than 2 years. All right, so what we got, we are prohibiting the sale, transportation, as it relates to lottery tickets from outside the United States, via the mail of the United States, or between the states of the United States. We are not allowing any sort of cross-border lottery ticket transportation of any variety. And we're certainly not allowing it using our mail system, which is the federal government's ability to regulate. The federal government has the exclusive ability to regulate the postal roads. See the Constitution of the United States for that proposition. So that's what we're trying to do. So you can have your lottery tickets within states, but if you're trying to transfer them between states, no bueno. Okay, great. That's easy enough. The indictment charged in its first count that on or about the first day of February in 1899 in Dallas County, Texas, Mr. Champion and others did there and then unlawfully, knowingly, and feloniously conspire to commit an offense against the United States, to wit, for the purpose of disposing of the same to cause to be carried from one state to another in the United States, in the state of Texas, to Fresno, in the state of California. Yeah, I mean, Dallas, Texas is a different state than Fresno, California. We are trying to transport the lottery tickets between states, and as it so happens, they are Paraguayan lottery tickets for some reason. I don't know why Paraguayan, but that's where we're sitting. Okay. Representing tickets as they knew, chances, shares, and interest in, and dependent upon the event of a lottery, offering prizes dependent upon lot and chance. That is to say, cause to be carried, as said, for the purpose of disposing. In other words, we're selling them, we're giving them away, whatever. They are to be given to the people of Fresno, which purport to be representations of shares, interests, in prizes which by lot and chance might be awarded. These grand jurors unknown, so they don't know who these people are, but we don't have to know specifically who they are, right? We don't necessarily need to know who the end client is as part of the conspiracy. We just need to know that you're transporting them for that purpose. That's enough under the statute. But we have to know that you're disposing them, but we don't necessarily need to know to whom exactly. We just have to show that you intended to distribute them to somebody. Anybody will be fine. Who might have purchased the paper, certificate, and instruments representing to be tickets, with numbers thereon and indicated and printed, which by lot and chance should on a certain day draw a prize or prizes at a purported lottery or chance company, to wit, the purported monthly drawing of the so-called Pan American Lottery Company, which purports to draw monthly in Paraguay. I don't know. That's just a thing. The Pan American Lottery Company is apparently a thing that exists in early 1900s America, and for some reason, the people of Texas and apparently California want to get in on the Paraguayan lottery. Okie dokie. That's what's happening. Which said Pan American Lottery Company purports to be an enterprise offering prizes dependent upon lot and chance. The specific method of drawing to be based upon unknown by the grand jurors. So again, we don't know specifically how you purport to decide who wins, but we don't need to know, right? We just need to know that you're doing it by some sort of lot or drawing. So we don't know whether or not you're picking names out of a hat or picking a card or doing bingo balls. We don't really know, and we don't really care. Any method of lot will be fine. Yeah, for a certain capital prize, which, you know, money, that's capital, amounting to the sum of $32,000. Okay, $32,000 in 1903 is quite a bit of money. We are competing for a $32,000 lottery in 1903. You can see why the U.S. government's interest has been captured by this. People are entering this lottery, or they think they are at least, because who knows for sure, right? We just think they purport to be tickets. So it could all be a fraud on top of everything else, was one of the problems with it being done through unregulated channels. You don't know whether or not they're genuine. And so it could all be a scam. Probably is a scam of some variety. I mean, yeah. Probably not completely 100% on the up and up if you had to take a guess, right? So they might be genuine tickets, but maybe not everything is exactly kosher here. And for the drawings for the capital prize or parts thereof to be allocated in conformity with a scheme of lot and chance. So this is not a skill-based game. Some version of drawing numbers. Were to take place monthly, the manner and form of which the grand jury is unknown. Again, we're not sure exactly how you're doing this, nor do we care. And were to be drawn or purported to be drawn under the supervision and direction of Enrique Montes de Leon, manager, and Bernardo Lopez, intervener, and which said papers, certificates, instruments purporting to be tickets of the Pan American Lottery Company were so divided as to be called whole, half, quarter, and eighth tickets. There are different kinds of tickets of different kinds of values, right? So rather than us sell you like 1 ticket, 2 tickets, 10 tickets, we're selling you either whole tickets or fractional tickets. I mean, whatever, right? It's all the same, no matter what we call it, right? But okay, we're selling some fractional ticket. A whole ticket to be sold for the sum of $2 for this $32,000 lottery. Half tickets for 1, quarter for the sum of 50 cents, and eighth tickets for the sum of 25 cents. Again, in 1903, this is some money. The indictment further charges, in pursuant of the conspiracy and to the effect of the object of the conspiracy, for the purpose of carrying from one state to another in the United States, to wit, from Texas to California, for the purpose of disposing of the same, to be representing tickets, chances, and shares and interest in, and dependent upon law and chance, as aforesaid, and then they well knew. So they knew what these were. They weren't confused. They didn't think they were something other than what they were. They thought, the allegation is they thought they were, in fact, lottery tickets. They knew they were lottery tickets, or at least they knew that they purported to be lottery tickets. They knew they were doing this. They did it intentionally for the purpose of it, as they say. And that Champion and Park did then or there, on or about the last day in the year of 1899 in Dallas, unlawfully, knowingly, and feloniously for the purpose of carrying it from Dallas to Fresno for the purpose of disposing the same, and caused to be deposited and shipped with Wells Fargo. So we weren't using U.S. mail. We were using Wells Fargo. The Wells Fargo's train be coming in with the lottery tickets into Fresno between states, which of course Wells Fargo did a lot of transportation of goods in this period of time. So not surprisingly, they were the UPS of their day. Carrying freight and packages from station to station all over the railway and from Dallas to Fresno for hire, one certain box or package containing, among other things, 2 whole tickets or papers of the lottery, one of which whole tickets is hereto annexed by the grand jury's indictment. So what they have as proof of the conspiracy is they have 2 tickets in the conspiracy, which apparently were placed with Wells Fargo for the purpose of transporting the tickets between states. And that would be the last trouble, the last scandal Wells Fargo would ever be involved in. All right, so that's what's going on in 1903 or 1899, I guess, is when this criminal case is starting. It appears that carrying the case was by the Incorporated Express Company engaged in transportation of freight. Okay, yeah. The commissioner who issued the warrant, having been found there was probable cause to believe the Champion was guilty, ordered that he give bond for appearance in the District of Texas or default to be commenced to jail. Having declined to give the required bond, the accused was taken into custody. So he is arrested. Thereupon, he sought out a writ of habeas corpus upon the theory that the act of 1895 under which it was proposed to try him was void under the Constitution. Okay, so he has been arrested in Illinois on this probable cause warrant that has as evidence 2 tickets, which were trying to be shipped by Wells Fargo from Dallas, Texas to Fresno, California. A warrant has been placed out under his arrest, commanding him to be transported back to Dallas, Texas. He is found in Illinois, where the warrant is issued. He is placed under arrest for transportation back to Dallas, Texas for trial. And now under arrest, he brings a habeas petition. He says, by what right am I being held in custody? By what right are you charging me under this law? This law is invalid because of the Constitution of the United States. I should not be under arrest and transported back to Dallas to stand trial for this conspiracy. All right, so we have to challenge the constitutionality of the law. So let's go ahead and do that. All right, this case was first argued in 1900, but re-argument was then ordered in 1901 at the same time as a different case of Francis v. United States. The 2 cases were argued in 1901 and commencement were ordered to be set for re-argument. So this sometimes happens, although it's a little bit rare to go from session to session. It is not incredibly unusual, although still rare by, I guess, absolute comparison. But it's not incredibly unusual for multiple different cases to be working their way through the United States at the same time. And it's not unheard of for any court, for that matter, to consolidate cases. You see them happen at all stages of proceeding. You see them happen at trials. You see them happen on appeals. You see them happen at the U.S. Supreme Court, right? The issues are close enough. If in the issues of judicial efficiency, we can hear multiple different cases and do that, then great. So it is not uncommon for 1, 2, 3, 4 cases to be consolidated and heard at the same time because they all deal with extremely similar issues. What is slightly more unusual here is that this is happening between terms. So we had one oral argument, and then for whatever reason, there was another case that was happening at, the next term, and the Supreme Court's like, oh, that's very, very similar. And it's similar, but we want to hear both cases. So the Supreme Court says, fine, we'll hear both cases. All right, how would you like to come back and argue again as part of a consolidated case? So that's what happened. That was consolidated. All right, great. The 2 cases present substantially the same question, which is, pretty much definitionally true when you're consolidating. As to the power of Congress to suppress lottery by prohibiting any person from causing lottery tickets to be carried from one state to another, and alike involve the constitutionality of the provision of the Act of Congress of 1895, generally known as the Federal Anti-Lottery Act, and which contains 3 different offenses, namely the use of the mail, importation from abroad, and causing them to be transported between states. Great. The courts below erred in sustaining the prohibition legislation in question because the suppression of lotteries is not an exercise of any power committed by Congress. So this is part of the argument. This is the Supreme Court's conclusion. They're noting what the argument is. Okay, so why are they saying the courts were wrong? Well, they're saying it because the suppression of lottery is not an exercise of any power committed to Congress in contravention of the 10th Amendment, which provides that the powers not delegated to the United States are nor prohibited are reserved to the states. So this is an enumerated powers question, right? That's how we would phrase this today, right? The federal government is one of enumerated powers. In the first instance, the states have all the power. In the first instance, the federal government has no power, right? The Constitution by its nature changes that relationship, but the federal Constitution is one of enumerated specific powers. The Constitution does not grant the federal government generalized power, which is what we sometimes call police power, the general power to do stuff. Federal government does not have the general power to do stuff. The states have general powers to do stuff, but not the federal government. The federal government, it has power at all needs to find some specific provision that gives it power. And so the argument is, well, there is no provision in the Constitution that says Congress can suppress lotteries, which, to be fair, there's not. Right? That language does not appear. So if it's going to be there, we need to find it somewhere else. And we already know, spoiler alert, where it's going to be, the Interstate Commerce Clause, but they note that it's not there by itself, which of course it's not. They then argue the sending of lottery tickets or policy slips does not constitute or evidence any transaction belonging to interstate commerce and is not within the power of the national government to regulate. So it is not a transaction. It is not a sale. It's, something different. I mean, okay, fine. And then they say the power to regulate lotteries and permit or prohibit the sale of lottery tickets is exclusively within the jurisdiction of police powers. So the federal government has no power to regulate lotteries, to create a lottery, to sell lotteries, so the argument goes. Right? The states have the power to do stuff. They have all the power to do stuff in the first instance. The federal government only has so much power as the Constitution gives it. The states have everything in reserve. So therefore, they argue that this must be a reserve power. It's up to the states to determine whether or not to issue lotteries. And I mean, even today, that's at least partially true. States make the decision as to whether or not to have lotteries or not, or gambling or not. Those decisions are made. And as to gambling, what kind of gambling? Do you allow bingo? Do you allow card games? Do you allow slot machines? Do you allow sports betting? And different states have different rules. Some states basically allow everything. Some states only allow a few things. It's up to each state to make those determinations. Hello, T-ish in Tennessee. It's nice to see you as always. And to all of you who are the uncivilians. All right, let's continue reading on. It cannot be reasonably doubted the intention and purpose of Congress in the legislation now before the court was to suppress lotteries. I mean, yeah. That there is no necessity to resort to the proceedings of Congress in which the purpose was openly avowed, for it appears in the face of the act itself, in its title, and impliedly in the nature and reasonable effect. Yeah, to the extent we care about policy or intent of Congress, it's in the text. Doesn't take a lot of going on. $5 from T-ish in Tennessee. Uncivil Law, no clue why I keep saying I'm new. You're about to get rated by TOTC. Excellent news. I'm very, very happy. Yeah, I very much appreciate all the people who are here and joining the channel as always. We are, for those of you joining us from Trials of the Century, we are covering the 1903 case from the United States Supreme Court dealing with the regulation by the U.S. government as to lotteries. We are doing this partially inspired by a recent drama that has occurred on Twitch, which has had a very interesting couple of days as it relates to gambling and schemes of gambling and fraud by streamers, or purported fraud by streamers and stuff like that. So in spirit of the inspiration of Twitch's woes dealing with gambling, I thought we would do a foundational case that speaks to the federal government's ability to suppress lotteries between states. So I appreciate everyone who's joining us. So let's go ahead and continue on with that. I appreciate everyone who's joining us from the Trials of the Century stream. I appreciate it. Let's continue on. Okay. So yeah, it's not at all vague what Congress is trying to do. They're trying to suppress all the things when it comes to the lotteries. We got that down. Yeah. We're not unclear. Yet hitherto, no one has asserted that Congress has the power to suppress lotteries any more than it has the power to suppress insurance or speculation about other businesses between residents of states not relating to interstate commerce. right? So no one has argued Congress has the power. So I guess we have to do that now in the first instance to decide whether or not Congress has the power. So exciting. All right. Oh, Lawn Lumber donates 50 gift memberships. That is incredibly generous, Rob. Thank you very much, Lawn Lumber, for donating those 50 gift memberships. And I welcome the 50 of you who now become part of the Uncivilians. You are instantly cooler than all the people who do not have the cool scales by your names. And you should feel marginally better about yourself via comparison, because you, my friends, are the Uncivilians. It is super appreciated. Thank you. Let us continue on. Yet on behalf of the United States, it is now urged in support of the legislation. Oh, Tish in Tennessee joins Rob by also gifting 50 Uncivil Law memberships. Well, thank you very much, Tish in Tennessee, for matching Rob's incredible sponsorship by also donating 50 memberships to the Uncivilians. You are now also part of the Uncivilians, and we appreciate every one of you who is here and part of the channel and joining us. Thank you very, very much, Tish in Tennessee, and also, of course, Lawn Lumber, and to everyone who is now getting the notification that, yes, you too are part of the cool Uncivilians. Tish in Tennessee gives $2 to say, Rob beat me by 5 seconds. Well, you guys can fight it out amongst yourselves who had the idea first. But you think the Tish is like fish, so it's Tish? Tish in Tennessee? Okay, noted. Tish in Tennessee, then. But when has there ever been a problem with me in pronouncing names? When has that ever been an issue? Let's press on. Okay. So, yes, yet is offered on behalf of the United States in support of the legislation that there is a federal police power of the broadest scope to be administered by Congress in absolute discretion and not reviewable by the courts. That's a lot. So, first of all, the federal government has police power, and second of all, the Supreme Court has no power to review our police power. That's a lot. Lawn Lumber gives 20 gift Uncivil memberships. Thank you, Lawn Lumber, for your additional 20 gift Uncivil Law memberships. I feel all the love and support. I do appreciate it very, very much. Yeah. Your real name is Letitia? Real name is Letitia. Letitia. Hello, Letitia. Hello, Tish in Tennessee. Letitia, thank you very much for being part of it as always. And yes, I do appreciate the membership fight. And Letitia gives an additional 20 gift memberships. 20 gift memberships as part, when then Lawn Lumber, not to be outdone, gives yet another 50 additional gift memberships for the Uncivilians. I appreciate it very, very much. Wow, I appreciate you all for your Letitia. Would you like to join Rob in his Lawn Lumber gets $2 to say we're just going all in tonight? I appreciate that. I will take your going all in. I appreciate it. I'm gonna have to go and get the bourbon if Brendan Laskus shows up. But we'll see. Steve A gives $5 to say lots of new Uncivilians. This is a good thing. It is an incredibly good thing. We appreciate it. Thank you very, very much. Letitia is pronounced Letitia. Yes, but it wasn't written Letitia. It was written with the way I read it, at least, unless it was my dyslexia. It was with T's. It wasn't Letitia. It was written Letitia. It wasn't written with a C. Did I misread it? I know how to pronounce Letitia. Not even close. Yeah, it's Letitia. Letitia is what she wrote. Letitia. That's what I went with. I'm doing my best over here. Tish in Tennessee sounds like Tisha. It is? It's Letitia despite the double T's? Okay. Letitia. Latisha. We'll get there eventually. Thank you, Letitia. Thanks. Think militia? Noted. I tried. I tried. I failed horribly as the Uncivil Law. But you know, we do our best. Thank you, Letitia and Rob, for your very, very generous super chats. It's fine. I'm used to it. Yeah, but you know, you're one of the uncivilians. You deserve better than that. So I feel slightly bad about it, but we'll try to get it right. Tracy C gives $4.99 to say hi, Kurt, with some cowboy hat emojis and orange heart emojis. Tracy C knows the way to my heart with the cowboy hat and orange hat emojis. Thank you very much, Tracy C, for all that. Okie doke. Let's try to cover more of the story. 242 of you have now become members during this stream. Between all the gifts, 242 new members, and it is very, very appreciated. Thank you very much. All right. Dawn I Jomo says, "You're awesome. Maybe it's Latish like fish ah." I think we best just move on and pretend that I'm competent. All right. Continuing on with the U.S. Supreme Court. You're going to have to raid some subscribers, re-notify your subscribers. I don't even know what that means. How would I go about doing that, re-notifying my subscribers? I don't even know what that means. Anyways, carrying on. No such absolute power in respect of police regulations was ever intended to vest in Congress. So right away, the Supreme Court notes that not so much with the police powers. Again, by police powers, we mean the general power to do stuff. It's a legal term of art. It means the power to do basically all the things. And no, not so much with the police regulations. For you, Congress, you are a government of enumerated powers. SEK 100 from entry required says Uncivil Law. My first introduction to Donald Trump was in the early 80s. His companies were clients of the law firm. I ran the computers. I didn't like him. He promoted gambling. And Letitia in Tennessee gives $2 and says, and now back to the U.S. Supreme Court. We're trying to get there eventually. So not so much with the absolute police power, no. On the contrary, it is well settled. There is no such thing as federal police power. And I feel like right there, you should just stamp that in the stone and send it to various members of Congress, because it would be nice for them to remember that there is no federal police power. Again, the term police power here doesn't mean that the federal government can't have law enforcement. The term police power means something a little bit more specific, or a lot more general, I suppose, in some ways. It's the general power to do things. They do not have the general power to do things. They may be able to do law enforcement. After all, the executive is to execute the laws of the United States, so they necessarily have law enforcement power, but they do not have police power. Okay, except in respect to those specific subjects delegated to Congress, such as treason, counterfeiting, piracies, and felonies on the high seas, and offenses against the laws of nation. Of course, in exercising these delegated powers, Congress may create crimes and add sanctions without the law, which the law exists, but in name. So yes, you can make things illegal, but only to the extent that you have specific power to enact in those domains. Authority to legislate on a given subject necessarily includes authority to punish anyone by whom the laws are violated. But this incidental power to enforce legislation cannot extend the jurisdiction of Congress to subjects not delegated to the national government. Yeah, the fact that you can make some things illegal does not mean you can make all the things illegal. States can make all the things illegal. At least they could in the first instance. You are a government of limited and enumerated powers. Law and Lumber gives an additional 50 gifts and creates 50 different new uncivilians. Thank you very, very much for your wondrous, generous super chat contribution. It is extremely appreciated. Thank you. Okay. It says, cannot be extended to the national government or support legislation not necessary and proper for carrying into execution the power to regulate commerce or any other delegated power. In the case at hand, the prohibition in question is true, may well be deemed necessary and proper for the suppression of lotteries, but it has no relation to interstate commerce and therefore is not necessary and proper for carrying out the execution of that power. So, yeah. So the argument is, again, that these are not interstate commerce. Letitia, continuing the trend to see who can outgive who. Letitia from Tennessee gives an additional 50 gift memberships in helps to support the channel. At this point, basically, everyone in the chat has a membership to Uncivil Law. I appreciate it very, very much. Lawn Lumber can give them to anyone who has enabled gifts for Uncivil Law. It doesn't restrict it to those hearers. Yeah. I think they have to enable it. Lawn Lumber says, watch historical Supreme Court cases, get memberships. I appreciate that. Michelle Curl is a member for 4 months. Thank you for hitting that beautiful, beautiful join button. Where was I? Okay. Lottery tickets are at most mere evidences of contracts made wholly within the bounds of states, which contracts are valid or invalid according to the admissible law of the state where they made or attempted to be enforced. That's the argument. If the given subject thus attempted to be regulated be not commerce, it's not easy to perceive where the power comes from. Congress cannot conclusively determine what is or is not an article of commerce. That inquiry is essentially judicial. So what is or is not commerce is to be decided by the judicial branch. Unfortunately, as we all know, thanks in large part to Wickard v. Filburn, which I continue to curse with every breath that I have, pretty much everything is commerce, and it wouldn't be quite a long time after Wickard v. Filburn until the Supreme Court found something not to be commerce. For those of you who are interested, I believe the first such instance of them finding something not to be commerce was Prince versus United States, which dealt with the Guns in School Zones Act. I believe was the first time that they found something to not be commerce after Wicker. So it took only about 70 years. So, but whatever it is, it's up to Congress, it's up to the Supreme Court to determine, much like any provision in the Constitution, of course. A legislative fiat cannot make that commercial commodity which is essentially in its nature is not such. A transaction which is not commercial in its nature cannot become so merely by declaration of Congress. In the case of some other case, and you know it's old as shit because it doesn't say something U.S. something. It says in the case of Collins v. Virginia, and then says 6 wheat 264. Yeah, in the very, very early days of the U.S. Supreme Court, although, of course, you can cite them by their U.S. number. But in the very, very early days of the U.S. Supreme Court, actually, not that early, but for the first couple decades of the U.S. Supreme Court, the volumes were cited by the person who wrote them, like the clerk of court. I forget exactly what their formal position was called, but wheat was like whoever the compilator was at times. So it's part of his volume. So you know it's an old as dirt case, because it doesn't say 6 U.S. 264. It says 6 wheat 264. So you know it's as old as dirt. A conviction under the statute of Virginia for selling lottery tickets for a national lottery authorized by an act of Congress was sustained. A lottery ticket in all of its aspects is of the same nature as an insurance policy, which represents an analogous form of wagering contract. I don't know whether or not that's true or not, but is an insurance contract the same thing as a lottery? I mean, lotteries are usually just pure chance, and at least technically you don't want to win an insurance contract, so I don't, it's like, yeah. Both forms of contract depend upon chance, and uncertain events, and in principle cannot be distinguished in their nature. So the U.S. Supreme Court thinks that there might be some difficulty in distinguishing between lotteries and insurance policies. Okay. Bly Burke becomes a new member and Nancy becomes a new member. Thank you very, very, very much for hitting that beautiful, beautiful join button. In the case of Paul versus Virginia, and again, 8 Wall 168, so you know it's as old as dirt, it was distinctly held that the issuing of insurance policies in New York and sending them to Virginia to be delivered there was not interstate commerce. So selling insurance policies in New York and sending them across state lines to Virginia, not interstate commerce. So if lotteries are the same thing, then the logic would flow. Okay. These insurance cases cannot be distinguished on the ground that the transaction was not interstate commerce, because the agent of the foreign insurance company, and by here they mean a foreign U.S. state, so you will sometimes see one state referred to as foreign vis-a-vis a different state. So New York is a foreign state to Virginia. So you'll see that language sometimes. That, Sarah, becomes an uncivilian. Thank you very, very much for hitting that beautiful join button. So that cannot be distinguished on the ground because the agent of the foreign insurance company negotiated the contract of insurance in the state where the contract was to be finally completed and the policy delivered. Insofar as the law now under consideration is aimed against the lottery ticket or policy slip at either place where the paper started or the delivery is made, or at the place where the paper will find itself or where the contract may take effect at the end of the journey, is an attempt to interfere with the local and municipal laws, police regulations of either place. Again, we're using the term police here to mean the general power to do stuff. Lotteries wherever found are not interstate commerce, but at most interstate wagering, such as insurance and other forms of speculation on gambling. It is true that lotteries, which were once popular and extensively engaged in, had gradually fallen into disrepute and had become the subject of prohibition by most of the states. But the gradual prohibition on lotteries under state police power does not make them interstate commerce or diminish the power of states to permit, regulate, or prohibit them. This is continuing the argument, right? If the present question had arisen in the days of Marshall, when public opinion of the country was not as hostile to lotteries as it is today, and the federal government had sought to prevent the people of any state from dealing as they saw fit in the lottery of other states, it would have been held that Congress had gone outside its powers, which it conferred it. So they're saying here that this is not what the founders would have had in mind, which is as valid an argument today as it ever was. And this is not something they were attempting to deal with. Okay. The argument on behalf of the United States is the scope of the word intercourse found in some of the opinions of the court tends to prove together too much. It would make the power to regulate commerce embrace not merely the entire sphere of mercantile activity in any way connected with trade, but to all the relations of life insofar as they involve the transaction between residents of different states. The appellants do not dispute the proposition that the business of carriage for hire from one state to another of such transportation is a branch of interstate commerce. So transportation itself between states is commerce. I mean, things are being bought and sold. But it does not follow that Congress may, therefore, determine what may or may not be carried, irrespective of the nature of the thing carried. So just because the Wells Fargo wagon is bought and paid for does not mean that what it carries is necessarily interstate commerce. Of course, today we would just simply say it's the instrumentalities of commerce and call it a day. But in 1903, we're actually going to think about it for a minute. The broad powers carried by the government's brief would enable Congress to regulate or prohibit every form of domestic trade and contractual relationship between residents of different states, and prohibit the transfer of promissory notes, deeds, bonds, contracts for professional services, and so forth. It is admitted, of course, that no such power was intended to be delegated. All right, so then they're going through some more argument, and I think we can kind of skip some of the argument, and we'll go and let me find where the decision picks up, because I think we got the idea about the argument of what's going on here. So the Supreme Court continues to go through the exact arguments in detail. They go through the briefs in detail, current reading on. So they summarize everyone's argument in excruciating detail. which is something they don't do today, but we got the gist of it. So let me get to the right part of the opinion, which actually deals with the decision of the court. All right. So we just spent time reading the argument about why Congress can't do this. And we skipped the argument from the government as to why they can. And now we'll pick up with the actual opinion of the U.S. Supreme Court delivered by Mr. Justice Harlan. Incidentally, for what it's worth, and this might come as a slight surprise to some people, this is a 5-4 decision. This is a 5-4 decision about whether or not the federal government has the power to forbid items being transported as part of regulating interstate commerce. So this is right on the line. And it's surprising because, of course, well, it's surprising not for least of reasons that Wickard v. Filburn, for example, was unanimous. So I guess it goes to show how much the Supreme Court changed in a lot of ways, is one of the reasons it's surprising. So in 1903, the Supreme Court says 5-4. Yeah, we think that you have the power to prohibit the transportation of lottery tickets across state lines. Fast forward 30 years, 9-0, the U.S. Supreme Court says, we think the federal government has the power to prevent a person from growing wheat on their own land. I find that remarkable. I find that just remarkable. 5-4, right on the razor's edge of whether or not this is within the bounds or outside the bounds. Geez, I don't know. The transportation of lottery tickets, the forbidding of transportation of lottery tickets across state lines. Geez, is that really something the federal government can do? I don't know. Is that commerce? Is that regulation of interstate commerce? I don't know, man. You know, geez, they have the power to regulate commerce, but can they really forbid things from being transported across state as part of a regulation? 5-4, right on the razor's edge. 30 years later. Oh yeah, you could totally prohibit a person from growing wheat on his own land for his own consumption. That's totally something you can do. No problem. I find that amazing. But that's where we're at. So here's Mr. Harlan delivering a 5-4 opinion of the court. The appellant insists the carrying of lottery tickets from one state to another by an express company engaged in carrying freight and packages from state to state, although such tickets may be contained in a box or package, does not constitute and cannot constitute commerce amongst the states within the meaning of the clause, providing that Congress has the power to regulate commerce with foreign nations and among several states and with Indian tribes, and therefore Congress cannot make it an offense to cause such tickets to be carried. The government insists that these express companies, which engaged with for hire in the business of transportation from one state to another, are instrumentalities of Congress, and there's basically your magic words today. If you want the magic words, instrumentalities of Congress is, that of commerce, that the carrying of lottery tickets from one state to another is commerce which Congress may regulate, and that means of executing the power of regulating may make it an offense to cause them to be carried. So regulation includes forbidding. The questions presented by these opposite contentions are of great moment, great importance, and are entitled to receive, as they've received, the most careful consideration. What is the import of the word commerce as used by the Constitution? That's a great question. What does that mean? That is a fantastic question to ask. It is not defined by the Constitution. Undoubtedly, the carrying of a thing from one state to another by independent carriers of things that are ordinarily subjects of traffic and which may themselves be recognized in value in money constitutes commerce. But does commerce among the several states include something more? Does not the carrying from one state to another by an independent carrier of lottery tickets that entitle the holder to payment of certain monies thereon also constitute commerce? Is this commerce? It is contended by the parties that these questions are answered in the forms of decisions of this court. The government insists the principles heretofore announced support of its position, while the contrary is confidently asserted by appellants. So they both claim that the Supreme Court has decided the precedent in their favor, which I suppose from the 5-4 nature of the decision was a fair point of dispute. This makes it necessary to ascertain the import of the decisions. What do they say? Upon the inquiry that we now enter, premising that some propositions were advanced in argument that need not be considered. In examination of former judgments, it will be best looked at them somewhat in order of when they were rendered. Not a bad idea, because maybe the case law has moved, and maybe there's an overall track of the cases or an overall direction of the cases. And so we can see the laws moving in a direction by putting them on a timeline. When prior adjudications have thus been collated, the particular grounds upon the judgment in the present case must necessarily rest can be readily determined. We can see the pattern, we can see the principle that is emerging or has been recognized or codified or otherwise distilled from the consideration of cases. We may here remark that some of the cases referred to need not bear directly upon the questions needed to be decided, but attention will be directed to them as throwing a light upon a general inquiry as to meaning and scope. So some of their decisions may not necessarily have language that is useful for our purposes, but nevertheless may contain an essence that reflects a direction of decision-making or reflects a thrust of decisions. So the different cases will be useful to us to different degrees. Some cases may be useful directly, in some cases more in terms of their overall gist or gravamonde. The leading case upon the decisions of the Constitution is Gibbons versus Ogden, which we will definitely refer to in one of our great cases series at some point. Gibbons versus Ogden, OG, some OG commerce stuff. Referring to that case clause, Chief Justice Marshall said, "The subject to be regulated is commerce, and our Constitution being, as was aptly said, one of enumeration and not of definition, to ascertain the extent of the power, it becomes necessary to settle upon the meaning of the words." Great place to start. The counsel for the appellee would limit it to traffic, to buying and selling, or the interchange of commodities, and do not admit that it comprehends navigation. Yeah, that would be Gibbons versus Ogden. Yeah, does it deal with the boats between ports? Steve A. gifts 10 Uncivil Law memberships. Thank you very much, Steve A., for your generous contribution to the Uncivilians. It is extremely appreciated. Thank you. I am really, really appreciating everyone who is helping to support this channel and here to enjoy the legal analysis of this channel. I hope you find this interesting and find the backbone of these legal decisions as interesting as I do. It's interesting to see how things have changed, where they come from, what decisions were once thought hard that are now thought easy, where things came from. It's helpful to understand these things as we understand all that. Okay, let's see. The counsel for appellee would limit, okay, we read that part. This would restrict a general term applicable to many objects to one of its significations. Commerce undoubtedly is traffic, but something more, it's intercourse. I do like how they keep using the word intercourse to refer to trade. Okay. It describes commercial intercourse between nations and parts of nations and all of its branches, and regulated by prescribing rules for carrying out intercourse. Well, rules for carrying out intercourse. Yeah, okay. It has been truly said that commerce, as the word is used in the Constitution, is a unit, every part of which is indicated by the term. If this be the admitted meaning of the word, its application to foreign nations, it must carry the same meaning throughout the sentence and remain a unit unless there be some plainly intelligible cause which alters it. Yes, very good principle of law, generally speaking, right? If you are using a word in this is a good interpretation note. If you're looking at a word in a statute, right, and you see the same word used, it probably means the same thing, right? And if you see different words, they probably mean different things, right? Because Congress, being a smart Congress, which I know you have to suspend your disbelief and just pretend. But nevertheless, Congress being a smart Congress, when they want to mean the same thing, they're going to use the same word. And when they want to mean different things, they're going to mean different words. So our presumption, therefore, interpreting is the same word means the same thing. And so if you are interpreting a statute or a constitution or a regulation or whatever, and you come upon the same word multiple different times, it probably means the same thing multiple different times. So always a good place to start. Within, of course, the scope of the statute or regulation or constitutional provision, as the case may be. Once you get from one statute to different statutes, right? Once you get from one thing that Congress passed, one bill they passed, for example, to a completely different bill, well, all bets are off. Maybe they meant different things. But, yeah. Okay, the subject to which the power is next applied to commerce among the several states. The word among means intermingled with. Yeah. Steve A. gifts 10 additional Uncivil Law memberships. Thank you very much, Steve A., for your thoughtful contribution to the Uncivil Law, Uncivilians. It is extremely appreciated. When we update the list of names during the next filming, there's going to be a lot more list of names. Yeah, I updated the list of names before filming today, by the way. And so the names at the top, they update because I have to update the list manually because of the way I do it, which I don't know if there's a better way to do it, but whatever. Anyways, and so I will update the list, and I appreciate everyone who will be on the list next time. It is very, very appreciated. Thank you. I have to figure out if there's a way to call the names directly. Probably. Anyways. Okay. Continuing on. The word among means intermingled with. A thing that which is among others is intermingled with them. Commerce among the states cannot stop at the external boundary line of each state, but must be introduced into the interior. It is not intended to say the words comprehend that commerce, which is completely internal, I'm going to say this, and I'm going to pretend like it's still good law. I'm going to move into my happy place, and I'm going to pretend for a minute. It is not intended to say that these words comprehend that commerce, which is completely internal, which is carried on between man and man in a state, or in different parts of the same state, and which is not affect to or extend to or affect other states. Such a power would be inconvenient and completely unnecessary. Comprehensive as the word among is, it may very properly be restricted to that commerce which concerns more states than one. The 1903 Supreme Court would like you to know that interstate commerce means among and intermingled with. And the 1903 U.S. Supreme Court would like you to know that interstate commerce does not mean and is not intended to mean state commerce, which is completely internal, that is carried on between a man and a different man in the state or different parts of the same state, and which does not extend to different states. Does not mean intrastate activity. Well, that's a law in 1903. It was nice, wasn't it? It was nice when interstate commerce meant interstate, when it meant between states. And it was nice when the Supreme Court wrote that it doesn't mean commerce that happens within a state or different parts of the same states. Wasn't that nice? Let's just move to a happy place where that's still the law today. happy place is over now. Pam asked, am I trying not to laugh or cry? I don't even know, man. I don't even know. Okay. The genius and character of the whole government seems to be that its action is to be applied to all external concerns of the nation and to all internal concerns which affect the states generally, but not to those which are completely within a particular state. Not to those that are completely within a particular state, says the 1903 U.S. Supreme Court. Okay. Which do not affect other states and to which is not necessary to interfere for the purpose of executing against the general powers of the government. Again, we are now arrived at the inquiry, what is the power? It is the power to regulate. That is the power to prescribe the rule by which commerce is governed. The power, like all others vested in Congress, is complete in itself, may be exercised to the utmost extent, and acknowledges no limitations other than those prescribed in the Constitution. Which is, I suppose, to say the enumerated power is the enumerated power, which is kind of tautological, but okay. Claude Simeon says, how did the interstate commerce change? Well, how did it change? Well, my friends, let me tell you about a little case called Wicker v. Filburn. Let me tell you about a little case called Wicker v. Filburn. Should I go into detail about this again? Should I do my Wicker v. Filburn rant? Let me do my Wicker v. Filburn rant. Okay, fine. All right, fine. Let's talk about this case. This is okay. All right. So the United States government passes a regulation that gives people a benefit, a tax benefit on wheat, and they want and also as part of the bill creates a price for wheat. The U.S. government guarantees a minimum price for wheat. Okay, it says wheat will sell at no less than X. The U.S. government is willing to buy it at X, right? In other words, they are guaranteeing a price floor, right, for wheat. Okay, and so as part of this price floor for wheat, they say, in so many words, that people are limited to how much wheat they can grow. Because, they want to only spend so much money, and they want to, limit how much money people can collect. Now, they could just say, for example, like, we're only going to pay for X wheat or whatever, but no, they just flat out say you can't grow more than that, okay? So there's this guy called Filburn. I believe he's in Pennsylvania, if memory serves correctly. And Filburn has a farm, E-I-E-I-O. And on this farm, he has some pigs, E-I-E-I-O, and some horses, E-I-E-I-O. And he grows wheat on his land. He grows the wheat for himself and his pigs and his horses and so forth and so on. Okay? Now, he grows more wheat on his land than he's allowed to by law. Because as I mentioned, right, the U.S. government guaranteed a price for wheat and said you could not grow more than X wheat. He is growing more than X wheat. Here's the kicker. Filburn is not selling any of his wheat. Okay? He uses all his wheat. He consumes all the wheat he grows. He grows more than he's allowed, but he sells none of it. He uses all of it. Either he eats it, or his pigs eat it, or his horses eat it. E-I-E-I-O. All right? And so the U.S. government comes along and says, hey, you can't do that. You can't grow that much wheat, Filburn. You have to go buy the wheat. You can't grow that much wheat. And he says, that kind of sucks because I want to grow the wheat because I'm using it. I'm eating the wheat, or my pigs are eating the wheat, or my horses are eating the wheat, or whatever. I am using all the wheat. And the federal government says, well, you can't because that's interstate commerce. And Filburn says that's insane because it's neither interstate nor commerce. It's not interstate because I am growing all the wheat on my own land and I am consuming it on my own land. Not only is it not interstate, it's not even really intrastate because it doesn't leave my farm. I use it all on the farm. So it's not going between states. It's not even going within the state, mind you. It's on my farm. It doesn't leave my land. It's just staying here. It never moves from here. It just stays on the land and just does its wheat thing, and it doesn't move between states. So one, it's not interstate. Two, it's not commerce because I'm not buying it. I'm not selling it. I'm not even giving it away, mind you. I'm consuming it. So it's not interstate, nor is it commerce, says Filburn. Federal government has the power to regulate interstate commerce. What I'm doing is intrastate non-commerce. So, how can interstate commerce include intrastate non-commerce? Well, the U.S. Supreme Court 9-0 says no problem. No problem, because the non-interstate, non-commerce is interstate commerce. How, you ask? Well, you see, the U.S. Supreme Court says it has impact on interstate commerce. Because you see, the thing is, because he grew his own wheat, he didn't have to buy the wheat that he needed, you see. Because, you see, he needed more wheat than he was allowed to grow. And if he had only grown as much wheat as he could have grown, then he would have had to buy the additional wheat because he needed the wheat. He needed it for himself and his pigs and his horses, E-I-E-I-O. And so because he grew it, he didn't have to buy it. So his non-interstate non-commerce has an effect on interstate commerce because he's not buying the stuff. And if everyone grew their own wheat, that would just have a massive effect on interstate commerce because all those people would not be buying it. They would be growing it for themselves and their pigs and their farmers, E-I-E-I-O. And that would have a massive ripple-on effect in the interstate commerce. So the non-interstate, non-commerce becomes interstate commerce. 9-0, Wickard v. Filburn is a case that drives me absolutely crazy and up the wall. And that's where it's all changed. Thanks so much for asking that question, that we could go down that wonderful rabbit hole of pain. Law and Lumber gives 5 gift memberships, and Letitia gives 5 gift memberships, and Kelly becomes a new one civilian. Thank you very much. Yeah. And then the circumstances apply to weed too? Yes, they do. Yes, they do. And that would be done in a case called Reich, which would be like it was Reich versus Gonzalez. When was Gonzalez Attorney General? Under Bush? So it would have been like 2006, maybe? Anyways, so there was a case dealing with the marijuana thing. It's like, hey, can we ban marijuana? And Justice Scalia, one of the things that disappointed me the most about Justice Scalia, 7-2 decision from the U.S. Supreme Court, and Justice Scalia said, yes, the U.S. Congress can forbid the sale of marijuana in between states. he went the wrong way, and he broke my heart. He broke my heart. He broke my heart because, you know, it's growing weed on your own farm for your own use or whatever. Like, yeah, it should be the logic. That's Reich. It's Reich versus Gonzalez, and then Scalia over here, in what seemed to me to be a betrayal of originalist principles, said that Reich was wrong. My heart was broken a little bit that day. I'm not going to lie. Yeah. Carrying on. Incidentally, I as I've discussed before, I have this sort of pet theory that the regulation of marijuana is actually invalid under the 18th Amendment. And this is one of those theories that implies that maybe I was smoking my own supply or something. But I do have this legal theory, which I'm not sure anyone's ever actually tried in court. So it might be the most bizarre theory I've ever heard of in my life, but I'm not sure anyone's ever tried it. The 18th Amendment, as I'm sure many of you know, banned alcohol in the United States. Of course, the 21st Amendment would eventually overrule it. But I want to make an argument because I need a way to overturn Wickard, right? I need a way to overturn Wickard, at least as it relates to marijuana, right? So if I can't do it for everything, maybe I can do it for marijuana. And I want to make an argument that the 18th Amendment not only was a substantive decision, it was also a, what would you say? It was not only the decision on the text, right, to say alcohol is banned. I want to make an argument that the people who proposed and ratified the 18th Amendment implicitly made a legal determination that survives the repeal of the 18th Amendment, incidentally. They made a legal determination that survives the repeal of the 18th Amendment, that the 18th Amendment itself was legally required. I want to make an argument that the 18th Amendment implicitly recognizes that Congress cannot, by a mere bill, ban alcohol. Thus, the 18th Amendment itself is necessary. If they could have just done it by a bill, they would have just done it by a bill. So the 18th Amendment not only is the substance of banning alcohol, it also represents a legal judgment that the amendment itself is required in order to give Congress the power, right? And so even though the substance of the 18th Amendment has been repealed by the 21st Amendment, I'd like to make the legal argument that the underlying legal judgment that the 18th Amendment is legally necessary survives. And if the legal judgment, the 18th Amendment is required to ban alcohol, thus banning alcohol cannot be within the power of Congress to regulate by interstate commerce, because that would be the alternative, right? Why not just ban it through interstate commerce? We can't, says the 18th Amendment implicitly. We can't do that. Thus, we need the 18th Amendment. Okay? And if Congress doesn't have the power to ban the sale of alcohol by mere legislation, according to the legal philosophy underlying the 18th Amendment, then it must be true, says me, it must be true that Congress doesn't have the power to ban, for example, the sale of marijuana. Under the 18th Amendment, the 18th Amendment creates the 18th Amendment creates a binding legal interpretation on the Interstate Commerce Clause, right? So I want to argue the 18th Amendment. Basically, what I want to argue is that the 18th Amendment implicitly overturned Wickard v. Filburn, and that legal reality persists despite the 21st Amendment. How do you like them apples? That is my bizarre ass legal theory that I've conjured in the contours of my mind. It's like, how can I get past Wickard v. Filburn? And I'm going to use the 18th Amendment to do it. This is if you currently work for a national marijuana rights organization and would like someone to propose your bizarre shit legal theory in court, give me a call, because I have ideas. Law and Lumber gives an additional 50 memberships for the uncivilians. Thank you very much. Yeah. I don't think anyone has ever proposed the idea before. I think it might be a completely novel legal theory. But it's what I got. Okay, moving on. Sandra says your husband is the popo and you have him rolling. Hey man, it's just all law. It's just all one big ass legal argument, man. I'm going to use the 18th Amendment to overturn Reich. I'm going to use the 18th Amendment to overturn Wickard. I'm going to use the 18th Amendment to overturn most of the federal administrative states. The 18th Amendment is going to become my weapon, man. It's going to become my sword. It's great. He loves it. Fantastic. All right. Let's see. We arrive at the inquiry, what is the power? Is the power to regulate. That is the power to prescribe the rule by which commerce is governed. This power, like all others vested in Congress, is complete in itself, may be exercised to the utmost extent, and acknowledges no limitations other than those that are prescribed in the Constitution, which is to say, what the Constitution says is what it says, which is tautological, but whatever. These are expressed in plain terms and do not affect the questions which arise in this case or have been discussed at bar. If, as they've always been understood, the sovereignty of Congress, though limited to specific objects, is plenary as to those objects. So, again, they have absolute authority, but only in a limited dimension, which is fair enough. I mean, the states have absolute authority, which is also somewhat limited by implication of the Constitution, but yeah, to whatever extent they have it, they have it. Okay, fine. It's plenary as to those objects, the power over which commerce with foreign nations and among the several states is vested in Congress, as absolutely as it would have been in a single government, having in its Constitution the same restrictions on exercise of power as are found in the Constitution of the United States. So, their power is wide. Okay. Mr. Justice Johnson, in the same case, expressed his entire appropriation of the judgment rendered by the court, but delivered a separate opinion, indicating the precise grounds upon which his conclusion rested. Referring to the grant over commerce, he said, "My opinion is founded on the application of the words of the grant to the subject of it." The power to regulate commerce here has been granted, and I think I acknowledged Law and Lumber's 50 gift memberships from 5 minutes ago, but I was in such a ranty state, I'm not even 100% sure. So I'll just take the moment to thank him again, just in case I forgot, which is totally possible. I was a little bit lost. In the delves of the madman's 18th Amendment theory. So thanks again to Law and Lumber for the 50 gift memberships from 5 minutes ago. And thank you to Wish on a Fish for your kind cowboy hats and orange hearts. I appreciate it. They speak to me. Let's see, where was I? The states were unquestionably supreme, and each possessed power over commerce, which is acknowledged to reside in every sovereign state. The law of nations regarding man as a social animal pronounces all commerce legitimate in a state of peace until prohibited by positive law. The power of a sovereign state over commerce, therefore, amounts to nothing more than power to limit and restrain at its pleasure, which, this is the nature of police power, right? The police power, of course, is limited, for example, by the Bill of Rights, but in the absence of the Bill of Rights, like in the first instance, what is the police power? The police power is, in the first instance, unlimited. it's the general power to do stuff or not do stuff and change your mind. It is without limitation. It is absolute and total. And of course, the Constitution, by, for example, its structure somewhat limits that, and by the Bill of Rights somewhat limits that and stuff like that. But the police power, by its first instance, is, the power to do anything. So it is the power to do limit and restrain at its pleasure or not in the first instance, unless you can find some sort of limitation somewhere. And also, since the power to prescribe the limits to freedom necessarily implies the power to determine what shall remain unrestrained, it follows that the power must be exclusive. It can reside but in one potentate, and hence the grant of power carries with it the whole subject, leaving nothing for the state to act upon. The new lights are awesome. Thank you. Thank you very much. I really appreciate that. I'm looking for ways to make things better, and I really appreciate. I took the time to try to make the design nice, and I thought this design really worked nicely with the current color scheme, and it seemed to please my mood today. And I'm glad you like it. And we got different color schemes for different times. We have different color schemes for different times. So we got, I believe this is, I don't even remember which color scheme this is right now. But yeah, we got different color schemes for different times, and we got different possibilities. We can do like violet analogous. That's pretty cool too, right? We can change that. Get some purple under the table. That's cool. And we can do violet triadic, which I think is what we've been using. And we can do like all kinds of things. I even have one in green triadic. Ooh. I appreciate that you guys like it. Thank you. I'm trying to find ways to make things better and more interesting here on Uncivil Law, and I appreciate every one of you who's part of it. Okay. I need to do the yellow again for you. For you, Sandra, let me see what I got. Let's see. Oh, Azure Triadic. Like this? The yellow in the background? So that is Sky Blue Triadic. But that is with the purple below. You like that one? We love you, Kurt. Thank you very much. I appreciate it. Yes, and for those of you wondering about such things, it's just a color wheel. It's the magic of the color. It's the magic of the color wheel. So we can do our color wheel learning today too. We can have multiple different things. Hold on. All right. So like when I say triadic or I say analogous colors. All right. All right. So here's a standard color wheel. It's a 12-point color wheel. All right. So for example, if you're talking triadic, you're talking about the colors that are in the triad, right? So in this color, for example, red, blue, and green, as you can see, like they're the big triangles, right? Red, blue, and green are in a triad, right? There are three colors in the triangle, right? So that's a triadic relationship. If you want analogous relationship, you're looking for the colors that are next to. So for example, the red, the analogous colors are orange and pink. The colors next to it on the color wheel are analogous. So pink, red, and orange at the top would be analogous colors, analogous of red. The triadic colors are red, blue, and green. And then also you can do what's called split. You can do a split complementary, in which case you're doing red, the medium blue, and the medium green. So you go from the big triangle one step down. So the complementary color, like the complementary color to red, is the light blue at the bottom. They're opposing colors, right? Complementary colors. So red and the light blue are complementary. If you want to do split complementary, then you just split the light blue into its component parts, which at that point are just the blue and then green, the colors that are next to it. And thus the relationship in the color wheel. So for example, right now I'm doing the light blue split. So I'm doing a light blue triadic. So if you follow the light blue, right? The ones between the medium blue, really, the one between the one between the big triangles, right? The big blue and the one in the middle, right? And you look at the ones that are opposed to in the triangle, you see magenta and green, right? So you see that medium blue, magenta, and what's called chartreuse green, and thus are the colors you see behind me. It's just a color wheel, nothing fancy. $5 from Dawn I Jomo. Very cool lighting. I've thoroughly enjoyed your thoughts on 18th. Might need to make a tea. My favorite part tonight, your excitement and smile. Thank you very much. Yeah. So thus the color wheel, and you learn about relationships, and you can learn about like small relationship changes, for example. So for example, if you do light blue, so if you do sky blue triadic, that's what's behind me, is sky blue triadic. But if you do sky blue split complementary, then it would look like this. And that's a different relationship between the colors on the color wheel. Color wheels and you, the more you know. Yeah. So now, right, because that's a split complementary. So if you take a look, for example, at the color wheel again, right? So you take a look at the sky blue, which is that small blue triangle in the bottom left corner, right? You take a look at the sky blue, which is the small blue triangle, right? And you look at the color that's directly opposed from it would be orange. Those are complementary colors, right? So that sky blue, the small triangle, is directly opposed from orange. Right, that's complementary colors. If you want to do split complementary colors, then you just split the orange into its next two closest, which of course are the two that are next to it, right? So orange splits into red and yellow. So light blue to orange is complementary. Light blue to red and yellow is split complementary. And thus, the lights behind me are split complementary. Red, sky blue, yellow. Ooh. We got color theory and Supreme Court case law all in one. Many, many things. Law and Lumber gives 50 gift memberships to help support the channel. Evelyn gives $2 to say you look happier these days. I'm happier for you. Thank you. Jennifer Foley gives $2 to say cool. Law and Lumber gives 50 gift memberships. Thank you. Thank you very much. Now you guys know way more about color theory and color relationships than you ever wanted to know. It's just how things look on a color wheel. I appreciate all the new memberships. That is a lot of new memberships. Thank you. Thank you very, very much. Okay, so the principles announced in Gibbons were reaffirmed in Brown versus Maryland. After expressing doubt whether any of the evils proceeding from the feebleness of the federal government contributed more to the establishment of the present constitutional system than the deep and general conviction that commerce ought to be regulated by Congress, Chief Justice Marshall, speaking for the court, said, "It is not, therefore, a matter of surprise. The grant should be extended as the mischief and should be comprehended all for foreign commerce and all commerce amongst the states." I mean, it is a little bit mischiefy. I'll give him that. Considering the question as to where was I? Considering the question as to the extent of the power to regulate commerce with foreign nations and among the several states, the court reaffirmed the doctrine of the power was complete in itself and acknowledges no other limitation other than prescribed. Commerce is intercourse. One of its most ordinary ingredients is traffic. Trufflehound gives Australian $14.99. This chat is awesome. Looking forward to seeing you again here on 30th of September to help Kurt on his 12-hour marathon stream to raise money for the Be the Match. Well, the charity has changed to the American Thyroid Association, but otherwise, yes, on the 30th of September, we will be having a charity stream, which is already up on my channel, by the way, for those of you who are interested in such things. It is planning to start at 9 in the morning and should go for at least 12 hours, but probably will extend until midnight or until I basically get so tired I can't keep doing things anymore. And we will be using the charity stream to raise money for the American Thyroid Association to help bring awareness to thyroid cancer and to help bring hope for a cure. So make sure to tune in on the 30th of September for supporting thyroid cancer research, support of people who have thyroid cancer, all the rest of it. The stream is already posted, so you can go there and check that out. Be part of the cure for thyroid cancer awareness. It is appreciated. And Lumber gives 20 gift memberships. It is extensively appreciated. Thank you very, very much. The charity, by the way, changed because at the time the American Thyroid Association had not been approved, and so I needed a placeholder. And so, but then of course it got approved, and it's approved by YouTube. So any donations on that stream through the super chat function, for example, go straight to the charity. It's 100% straight to the charity. It never touches my hands. Thank God. I don't need that responsibility in my life. That's one of the reasons I wanted to get the charity approved by YouTube, so I don't have to deal with that stuff, right? So any sort of money that's raised by the super chat button, that's donated, goes straight to the charity. It's 100% goes to the charity. YouTube doesn't take a cut. Google doesn't take a cut, right? I don't take a cut. It's 100% charitable support, and it's direct through YouTube so that I don't have to deal with it, and so much the better. So yeah, anyways, carrying on. Tune in for that. In passenger cases, this court adjudicated certain statutes of New York and Massachusetts imposing taxes on alien passengers arriving in those ports of states to be in violation of the Constitution and laws of the United States. In separate opinions delivered by the justice that will not be found any expression of doubt as to the doctrines announced in Gibbons. Mr. Justice McLean said, commerce is defined as an exchange of commodities, but this definition does not convey the full meaning of the term. It includes navigation and intercourse. Truffle Hound gives $7.99 Australian dollars. Rob's out of controls with the membership, and the whole chat is green. Legend, this is excellent. And Baba Yogo gives $2. It's just a token of thanks to whoever gifted me. Well, it's either Lawn Lumber or it is Tish in Tennessee, also known as Letitia, who has been donating so much throughout the chat. Thank you very much. It is appreciated. Let's see where we were. The same views expressed by Mr. Justice Wayne in his separate opinion. He regarded the questions then before the court as covering the decision in Gibbons, and how respected the case, he said, it will always be a high and honorable proof of the eminence of the American bar that day and the talents of distinguishability of the judges who were then in places which they now occupy. What a brown noser, man. There was another super chat from that Sarah. That's true. That Sarah gave $5 to say Lawn Lumber's Make It Rain membership in your chat. I think it's because we all like seeing your genuine delight and the happiness it brings in you. Yeah, I'm much happier doing this and happier bringing you this quality legal content than I was before. And yeah, we don't need to talk about that more. But I do appreciate it. I appreciate that you've made this possible because it means that I can be happy. And I appreciate that you're here to help. You're going to make me cry. Okay. In Ames versus State of California, a statute of California imposing a stamp duty upon bills of lading for gold or silver transported from that state to any port or place out of the state was held to be a tax on exports in violation of the provision of the Constitution that declares no tax or duty shall be laid on articles exported from any state. But in Woodruff, this court, referring to Ames, said it was well decided upon a ground not mentioned in the opinion of the court, namely, that although the tax there in question was only on bills of lading, such a tax was regulation of commerce, a tax imposed upon transportation of goods from one state to another over the high seas, in conflict with freedom of transit of goods and persons between one state and another. So basically, at this point in the U.S. Supreme Court opinion, by the way, they're just trying to prove the proposition that Congress has lots of power when it comes to regulating interstate commerce, right? The thing we're trying to ultimately get to is Congress's ability to ban the transportation of lottery tickets across states. And so we're using the case law precedent to show that in the past, Congress has, for example, prohibited taxes or bills of landing or regulated the movements of people to the extent they are aliens or whatever, right? We're trying to prove that Congress's power has a lot of scope to show this is within the scope. So Miranda says, how am I just hearing about me now? I don't know, Miranda. I'm glad you're here. I'm glad you are hearing about me now. My name's Uncivil Law. I like to discuss the Constitution. It kicks ass. I'm glad you're here. Let's see. So I'll skip a little bit of this precedent because I think we kind of got the point that was there. They're just going through some more stuff and more history. So we'll skip a little bit of that. In County of Mobile versus Kimball, Mr. Justice Field, delivering the justice of the court, said commerce with foreign countries and among the states strictly considered constitutes in intercourse and traffic, including in these terms, navigation and transportation and transit of persons and property, as well as purchase, sale, and exchange of commodities. And then there's some more case law talking about some. In Western Union Telegraph Company versus Pendleton, the court recognized that commerce with foreign countries and among the states which Congress could regulate, including not only the exchange and transportation of commodities or visible tangible things, but the carriage of persons and transmission by telegraph of ideas, wishes, orders, and intelligence. $50 from Law and Lumber, who says, cheers, my friend. Whoa, what did I just do with the thing? Cheers, my friend. You've been through hell, and you're allowed to have a night where we get to celebrate the progress you've made. This channel is better than ever, content is awesome, and you, my friend, are happy, which means more than anything else. Yeah. It's difficult sometimes to know how much to talk about such things because I don't think, generally speaking, people really want to hear about negativity and people don't want to hear about your own problems or stuff. It's hard to judge such things. In terms of how much open you are or not. But for those of you who know, and those of you who've been watching the channel for any length of time, you know that I was going through some serious depressive issues, and I decided to make YouTube a full-time career in early July, which was only, 2 months ago? Or was it June? Might have been 3 months ago. I don't even remember now. Was it June or July? I forget. Anyways, it was one of them. Anyways, but so it's only been 2 or 3 months, but I'm a lot happier for it, and it's helped a lot, and I really appreciate that you guys are here. Thank you for all the orange hearts and cowboy hats. I do appreciate your guys' continuing love. In Covington, we don't need to continue going through the case law. Okay. At present term of the court, we've said that transportation for others as an independent business is commerce, irrespective of the purpose to sell or retain the goods, by which the owner may entertain with regards to them after they shall have been delivered. The reference to prior adjudications could be extended if it were necessary to do so. The cases cited, however, sufficiently indicate the grounds upon which this court has proceeded when determining the meaning and scope of the Commerce Clause. They show that commerce among the states embraces navigation, intercourse, communications, traffic, the transit of persons, and transmission of messages by telegraph. They also show the power to regulate commerce among the several states is vested in Congress as absolutely as it would have been in a singular government, having its constitution the same restrictions on the exercise of power as found in the Constitution of the United States. Which, I mean, yeah, I'm not sure what you're really trying to say there, but yeah, I mean, the power is the same as it would have been in a different form of government, I guess. All right. That such power is plenary, complete into itself, and may be exercised by Congress to its utmost, subject only to limitations as the Constitution imposes on the exercise of powers granted. And the determination of the character of regulations be adopted by Congress has large discretion, which is not to be controlled by the court, simply because, in their opinion, such regulations may or may not be the most effective that could be employed. We have come then to inquire whether there is any solid foundation upon which to rest the contention that Congress may not regulate the carrying of lottery tickets from one state to another, at least by corporations or by company whose business it is to hire to carry tangible property from one state to another. It was said in argument, $20 from Sandra Ramirez, you've inspired many of us to follow our hearts and dreams. Orange heart, keep up the great work. Thank you very much. That's very, very kind of you. Thank you. An audio dome. I'm glad you like the thumbnails. I'm really liking the thumbnails too, and I'm liking the. I'm trying to make things better for you constantly. I'm always trying to think of ways to make things better and to improve things, changing format, changing things, doing more pop stories. I released 6 stories today. I released 6 episodes today. This is my 7th thing today, I think. Yeah. And I also released a whole bunch of shorts on my shorts channel and released TikToks and with the transcripts imposed on them, and trying to do things that I thought would be interesting, changing the lighting scheme, changing the color scheme, changing things to make things interesting and fun. How about blue analogous? Too much blue? I'm blue, ba-da-bee-da-da-ba, ba-da-bee-ba-da-ba. I got a girlfriend, and she is so blue. All right, thank you very much. Okay. It was said that the lottery tickets are not of any real or substantial value in themselves, and therefore are not subjects of commerce. If that were conceded to be the only legal test to be what deems subjects of the commerce that may be regulated, we cannot accept it as accurate the broad statement that such tickets are of no value. Upon their face, they showed the lottery company offered to pay a large prize to be paid to the holder of the ticket winning the prize at a drawing advertised to be held in Paraguay for some odd reason. The notifications are having a tough time keeping up because there's so much support in the chat. It's a nice problem to have, I suppose. When 15 seconds per notification is too much. Okay. Money was placed on deposit in different banks in the United States to be applied by agents representing the lottery company to prompt payment of prizes. These tickets were the subject of traffic. They could have been sold, and the holder was assured the company would pay the amount held. That a holder might not have been able to enforce his claim in the course of any country making the drawings of lotteries illegal and forbidding the circulation of tickets did not change the fact that tickets issued by the foreign company represent so much money payable to the person holding them and who might draw the prizes affixed to them. If the holder did not draw a prize, the tickets before the drawing had a money value in the market among those who chose to sell or buy lottery tickets. In short, a lottery ticket is subject of traffic, and so was designed within the Act of 1895. That fact is not without significance in the view of what this court has said. That act, counsel for the accused well remarks, was intended to supplement the provisions of prior acts excluding lottery tickets from the mails and prohibiting their importation of lottery matter from abroad, and prohibiting the causing of lottery tickets to be carried and lottery tickets and lottery advertisements to be transformed from one state to another by any means or methods. Those notifications are an hour or more behind. Yeah. We're of opinion that lottery tickets are subject to traffic, and they're for subjects of commerce, and the regulations of carriage of such tickets from state to state, at least by independent carriers, is regulation of commerce. But it's said that statute in question does not regulate the carrying of lottery tickets from state to state, but punishing those who cause them to be carried. Congress in effect prohibits such carrying. Then the respective carrying from one state to another articles of things that are in fact, or according to usage in business, is subject to commerce. The authority to given to Congress was not to prohibit, but only to regulate. So this is the central argument here. It's like, okay, so this is commerce. Let's concede that ground, which I think is the easier ground to concede. This is commerce, but Congress, by the terms of the Constitution, has the ability to regulate interstate commerce, not prohibit interstate commerce. So is prohibition a kind of regulation? So that's like the more central thesis in some ways. Cool Springs gives 20 US, gives 20 memberships. Lionel Hutz says just use UPS. They were using UPS. UPS was known by a different name back then. It was called Wells Fargo. But, it's the same thing. Nothing new under the sun. But yeah. Law and Lumber says, y'all, I'm going to show you the Kurt I know, just in case you haven't seen it. I want the chat full of positive support, rightly earned by one who works harder than I've seen for what he loves. It's really nice, Law and Lumber. Thank you. It's nice, Rob. Thank you. I'm going to need some whiskey or something. It is to be remarked the Constitution does not define what is deemed a legitimate regulation of interstate commerce. In Gibbons, it was said the power to regulate such commerce is the power to prescribe the rule by which it's governed. But this general observation leaves it to be determined, when the question comes before this court, whether Congress in prescribing a particular rule has exceeded the power. While our government must be acknowledged to be one of enumerated powers, something that is often forgotten, to be quite honest, the Constitution does not attempt to set forth all the means by which such powers may be carried into execution. That is true, I suppose, but it does set the limits of what the execution is. But it doesn't set the means, but it does set the ends. I think is probably correct. Yeah, so it doesn't set the means, but it does set the ends. It leaves Congress a large discretion as to the means to be employed in executing. Sure. The sound construction of the Constitution, the court has said, must allow the national legislature discretion with respect to the means by which powers conferred are to be carried into execution, which will enable the body to perform the duties assigned to it in a manner most beneficial to people. Let the end be legitimate. This is a key in my view. Let it be within the scope of the Constitution. That's sort of the thing, right? The Constitution provides what ends there are and the limitations. Yeah, which are plainly adapted, and any means which are appropriate, which are not prohibited, are permissible. Yeah, so the correct question is what ends are permissible. I think that's exactly right. Julie says, I had no idea UPS was related to Wells Fargo. It's not. I was just trying to make a what would you say? An analogy without making it clear. I didn't mean it literally when I said UPS. They did use UPS. It was just known as Wells Fargo. I didn't mean that literally. I was just meaning it basically in the sense of there's nothing new under the sun, right? We were discussing this, for example, recently in the Fifth Circuit Court of Appeals decision when we were discussing the regulation of social media, and I basically made the same comment before because they were talking about regulation of the telegraph with Western Union. And so I was making the point, Western Union, so they're talking about Twitter, but here's this case from 1880 in which Twitter is going by a different name. It's called Western Union. All right, so I didn't mean it literally. I was just pointing out that it's basically the same issue all over again. But yeah, sorry if that wasn't clear. It's a spurious correlation, something like that, yeah. UPS, Pony Express. Yeah, exactly the same thing, right? We have said that carrying from state to state of lottery tickets constitutes interstate commerce, and that regulation of such commerce is within the power of Congress. Are we prepared to say that a provision, which is in effect a prohibition of carriage of such articles from state to state, is not fit or an appropriate mode for regulation? I mean, that is the question, right? If lottery traffic carried on through interstate commerce is a matter of which Congress may take cognizance and over which power may be exerted, can it be possible that it must tolerate the traffic and simply regulate the manner in which it must be carried on? I mean, that's the question, right? Or may not Congress, for the protection of the people of all states and under the power to regulate, devise such means within the scope of the Constitution, and there you're begging your own argument, you're assuming your own conclusion, you're assuming it's within the scope of the Constitution, as will drive that traffic out of commerce among the states. In determining whether a regulation may not, under some circumstances, properly take the form or effect of a prohibition, the nature of interstate traffic which is sought by the Act to suppress cannot be overlooked. I'm not sure the nature of the traffic is really relevant. Either Congress has the ability to suppress it or not. It shouldn't matter what the nature of the commerce. See, this is the thing, right? Looking at the specific thing, like this is a hard cases make bad law problem, right? If Congress has the power to prohibit interstate commerce, then they have the power to prohibit all the interstate commerce, right? Because the Congress, just by its own, because the Supreme Court just told you, right, the only limitations are the ones the Constitution imposes. Otherwise, it's plenary, which is to say absolute. That's another word for plenary, right? Except as, might be limited, right? So it's like, okay, if Congress has the power to regulate, they have the power to make all the regulations. If they have the power to prohibit, they have the power to make all the prohibitions. So the Supreme Court is making a bit of a mistake here, because it's like, let's look at the nature of the traffic that is being sought to be suppressed. That's a mistake. That's a mistake, because there's no limiting principle. There's nothing about this. Like, you can't split, it seems to me, you can't split the logic between different things in commerce, right? The power of Congress is to regulate interstate commerce. If you concede that the lottery tickets are interstate commerce, which I think you concede, I will give you that, right? Then the only question is, what does it mean to regulate? What does it mean to regulate interstate commerce? If Congress has the power to prohibit this as interstate traffic, they have the power to prohibit all the interstate traffic. And so the Supreme Court is doing a hard cases make bad law, right? The U.S. Supreme Court is saying, essentially, we're going to look at the fact that this is a lottery because we don't really like the fact that people are doing the lottery. But there's no limiting principle. And so it's a mistake to look at the nature of the thing, in my humble opinion. Yeah. When enacting a statute, Congress no doubt shares the views upon subject to lotteries, herefore expressed by this court. In Phelan, the Supreme Court said, after observing the suppression of nuisances injurious to public health or morals is among the most important duties of government, this court said, experience has shown that common forms of gambling are comparatively innocuous when placed in contrast with widespread prevalence of lotteries. That's an interesting thing for the Supreme Court to say. So gambling, according to the Supreme Court, gambling is innocuous compared to lotteries. I'm not sure that a person today would necessarily have that opinion. That's an interesting thing for them to write, right? It's like, well, gambling is one thing, but these lotteries, man, it's like, that's the real evil we need to suppress. Okay. The former are confined to a few persons and places, but the latter infest the whole community. It enters every dwelling. It reaches every class. It preys upon the hard earnings of the poor. It plunders the ignorant and the simple. Well, I mean, that much is true about lotteries today and before. But that lotteries are a unique evil compared to gambling in general, I don't know about that proposition, but okay. In other cases, we have adjudged that authority given by legislative enactment to carry on a lottery, although based upon consideration in money, was not protected by the contract clause of the Constitution. Yeah, nothing is. The contract clause of the Constitution is dead. Just admit the truth. It's all dead. This for reason no state may bargain away its power to protect the public morals. The state might not. See, this is a problem, right? Do states have power to regulate the public morals? Well, again, in the first instance, the states have police power, right? In the first instance, the states have all the power. They have all the power to do all the things. They can pass any law of any kind without any limitation. In the first instance, thus is the nature of police power. They can pass any law or any regulation of any variety to do anything at any time to anyone of any scope, right? It is an unlimited, absolute, total power is the police power. Now, of course, we have bills of rights. Of course, we have other things, right? But in the first instance. So in the first instance, do the states have the power to regulate against the morals? Sure they do, because in the first instance, the states have all the power to regulate for any reason that strikes their fancy, because they have absolutely no limitations of any variety. But, you know, there is, things. Way to go, Trish. Good job. If a state, when considering legislation for the suppression of lotteries within its own limits, may properly take the view of evils that inhere the raising of money in that mode, why may not Congress, invested with the power to regulate commerce among the several states, provide that such commerce shall not be polluted by carrying lottery tickets from one state to another? I like how now that it's a pollution of commerce, as opposed to just being commerce. Before it was commerce, but now it's a pollution of commerce, which implies it's not commerce, which would mean that Congress wouldn't have the power to regulate it. But let's not look too much into that, I suppose. What provision is the instrument can be regarded as limiting the exercise of power granted? Well, to my mind, the fact it says regulated is itself a limitation, but okay. What clause can be cited which on any degree consonances the suggestion that one may have right, carry or cause to be carried from one state to another, that which will harm the public morals? Well, the one state can ban it. Each state could ban it. That would be fine, right? Because each state has, in the first instance, the power to do all the things, right? So, like, what gives you the right to carry from one state to another? Lottery tickets? Well, if it's legal in both states. If it's not legal in both states, then the states have the power to prohibit it, right? Because they have the police power. So, like, if California is cool with it and Texas is cool with it, which seems to be presumed here, because they're not saying it's illegal by California law, or at least no one is mentioning it. But they could make it illegal by local law. That'd be fine. So what suggestion is there that one can carry from one state to another in a way that will harm the public morals? Well, everything is legal unless it's not. You yourself earlier said this, by the way. I'm not even making that up, right? You yourself, Supreme Court, said earlier in your own decision that all commerce is legal unless not. I'm paraphrasing. So what is the right to carry it in a way that will harm the public morals? Well, you're presupposing it harms the public morals, and only the state legislature can make that decision. So the Supreme Court's logic is a little bit questionable here in some ways. We cannot possibly think of any clause in the instrument that could possibly be invoked to those who assert the right to send lottery tickets from state to state, except the one providing that no person shall be deprived of liberty without due process of law. Well, it's also property, incidentally. Lottery ticket is property. So there's that too. We have said the liberty protected by the Constitution embraces the right to be free in the enjoyment of one's faculties, to be free to use them in all lawful ways, to live and work where he will, to earn his livelihood by any lawful calling, to pursue any livelihood or avocation, and for that purpose to enter into all contracts that may be proper. But surely it will not be said to be a part of anyone's liberty, as recognized by the supreme law of the land, that he shall be allowed to introduce into commerce among the states an element that will be confessedly injurious to the public morals. Again, you're presupposing the thing that you're trying to prove. Like, you're presupposing it's injurious to the public morals. And you're presupposing, like, that Congress has the ability to legislate on morals, which they absolutely do not. States do. Congress does not. States have police power. Congress does not have police powers, as you yourself acknowledged. So if it's injurious to the morals, can Texas ban it? Sure. Can California ban it? Sure. No problem, right? In the absence of something else, right, in the first instance, right, what is your default presumption? What is your default presumption in the first instance? Your default presumption is, can Texas do X? Your default presumption is yes. Yes, they can. You need to find some specific reason they can't. In the case of the federal government, you don't have that problem because they don't have generalized police power, as you have pointed out. They only have enumerated powers. So can Congress legislate for the morals? No, because there's no provision in the Constitution that says Congress has the power to legislate for the morals. It says Congress has the power to regulate interstate commerce, not to regulate interstate morals. So if the question is, can California ban it? Yes. If the question is, can Texas ban it? Yes. If the question is, could the federal government give effect to that by, for example, making it federally illegal to transport from one state to another where it would interfere with the respective state laws? Yes, I think that would be fine, right? They could make that federally illegal because you're transporting you're transiting state boundaries at that point. And if it's illegal under the state laws and you're transiting state boundaries, then that's an interest of the federal government. But does the federal government have the general power to regulate for the morals? No. But you are saying, Supreme Court, that it will not be said to be a part of liberty that they have the ability to regulate for the public morals. You're asking the wrong question. The question isn't part of liberty to transport the lottery tickets versus morals. The question is, what power does Congress have to regulate it? And it's not morality. That's not a reason. It's not power, at least. It might be a motivation, but it's not a reason. Right? You need something more, or it's arbitrary and capricious. So it doesn't quite work. Kendra Strike says, I look good without the beard. Well, thank you, I suppose. I like to change it up from time to time, so I'm glad you like the clean-shaven look. If it's to be said the Act of 1895 is inconsistent with the 10th Amendment, reserving to the states respectively or the powers not delegated to the United States, the answer is the power to regulate commerce has been expressly delegated. See, but you changed your frames of reference, Supreme Court. You changed your frames of reference within the space of one sentence, really. Yeah, because you talked about look how they change it. Look how they suddenly change the frame of reference. They change what you're talking about, and they hope you don't notice, right? They say, surely it will not be recognized as part of liberty that he shall be allowed to introduce in the commerce an element that will be injurious to the morals, right? And then they say, if it's said to be inconsistent with the 10th Amendment, the answer is that the power to regulate commerce among the states has been delegated. They want you to think that the ability to regulate morals is the ability to regulate commerce, but they're just like smashing it together. They change frames of reference. It's a subtle linguistic trick. And it's interesting, right? Because it's like, oh, we're talking about one thing, we're talking about another thing. We're hoping that you're just going to read from one to the other without noticing that we changed frames of reference. I'm on to you, Supreme Court. You can't fool me. Besides, Congress by that act did not assume to interfere with traffic or commerce in lottery tickets carried on exclusively within the limits of any state, but has in view only commerce of the kind among the states. It has not been assumed to interfere with the completely internal affairs of any state. I cry in Wickard v. Filburn. I cry sobs of Wickard v. Filburn at this point. And is only legislative in respect to a matter which concerns the people of the United States. Well, that's not much help. Yeah. As the state may, for the purpose of guarding the morals of its own people, forbid all sales of lottery tickets within its limits. Yeah, that's fine, because states can do that. So Congress, for the purpose of guarding the people of the United States against widespread pestilence of lotteries, and to protect the commerce which concerns all states, may prohibit the carrying of lottery tickets from one state to another. Why, if it's legal in both states? You're just kind of assuming your own conclusion, U.S. Supreme Court. Generous says, my subscribe button isn't red and sad and angry. It's gray and peaceful and calm. Be like Jen, hit subscribe. Make your subscribe button happy, support Kurt rocks. That is true. That is true. You know, please, if I may direct your attention, like Jen has so kindly reminded you, direct your attention to your subscribe button. Is it red? Is it angry? Is it mad? Is it mad with you? This can be cured merely by clicking that red subscribe button and will become calm, gray, and integrated. Just like Jen's subscribe button. Be the change you want to see in the world today. Let's see. It said the effect would not permit the declared policy of the United States, which sought to protect the people against the mischiefs of the lottery business, to be overthrown or disregarded by agencies of interstate commerce. We should hesitate long before adjudicating that an evil of such appalling character, carried on through interstate commerce, cannot be met and crushed by only people competent to that end. We may say competent to the end because Congress alone has the power to... Okay, so I see that we got some bot problems, so I have to put on restrictions in chat, but that's the way it goes sometimes. I think everyone's a subscriber basically at this point, so I'm not sure how much it will help, but give the moderators at least a break. You can have nice things. Let's see. What was said by the court upon a former occasion here will be repeated. The framers of the Constitution never intended the legislative power of the nation should find itself incapable of disposing of a subject matter committed to its charge. If carrying of lottery tickets from one state to another be interstate commerce, Trufflehound gives Australian $14.99. Is it true there's going to be a change to the Fifth Amendment to allow private properties to be open to international philanthropies on the 24th of December? It's the Santa Claus. Cute. I approve. I approve. I would point out that the Fifth Amendment, like all amendments to the Constitution save the 13th, only apply to governmental actors. And the Fifth Amendment does not apply to non-governmental actors. For example, Santa Claus. But I appreciate your super chat and your fine question. Thank you very much. The regulation may sometimes appropriately assume the form of prohibition is also illustrated by the case of diseased cattle transported from one state to another. Well, I mean, come on. If you want to say that the cattle can't be diseased, I mean, that seems like a valid regulation, you know, to prevent the spread of germs. Such cattle may, notwithstand their condition, a value of money for some purpose, and yet it cannot be doubted that Congress, under its power to regulate commerce, may either provide for them being inspected before transport. That sounds logical. Or its discretion may prohibit them from being transported from one to another. I'm not sure that really proves your point, but okay. Okay. The Act of July the 2nd of 1890, known as the Sherman Antitrust Act, and which is based upon the power of Congress to regulate commerce, is an illustration of the proposition that regulation may take the form of prohibition. The object of the act was to protect trade and commerce among unlawful restraint and monopolies. To accomplish that object, Congress declared certain contracts to be illegal. Well, contracts that restrict trade, which seems like a valid regulation of commerce to me, but okay. I'm not sure pointing to the Sherman Antitrust Act really proves your point, but okay. That's an interesting one. To accomplish that object, Congress declared certain contracts to be illegal. That act, in effect, prohibited them from doing certain things, and its prohibitory clauses have been sustained in several cases. Under this granted power to Congress, that body, in our judgment, may enact such legislation as declared void and prohibit the performance of any contract between individuals or corporation where the natural and direct effect of the contract will be, when carried out, to direct, and not merely incident to another and incidental innocent purpose, regulate any substantial extent interstate commerce. We do not assent to the correctness of the proposition that the constitutional guarantee of liberty to the individuals to enter into private contracts limits the power of Congress and prevents them from legislating upon the subjects of contracts of the class mentioned. The power to regulate interstate commerce is, as stated by Chief Justice Marshall, full and complete in Congress, and there's no limitation in the grant of power which excludes private contracts of the nature and the question from jurisdiction of the body. And I don't know about that at all, man. I mean, to say the Sherman Antitrust Act justifies this is a little bit weird. So the Sherman Antitrust Act basically says in Section 1 that any sort of contract to restrain trade is illegal, right? You can't create any sort of agreement between companies that restrains or otherwise segments off the market. So you can't, for example, as a matter of contract, have a grocery store which says, okay, well, my grocery stores will only be on the east side of town and your grocery stores will only be on the west side of town. That would be an illegal contract, for example, that would restrain trade. You can't have an agreement that says we will fix the price between us of tuna, and so forth and so on, right? You can't do that, right? So, you can't have agreements that segment off the market or fix prices or otherwise inhibit competition. That's the Sherman Antitrust Act in basic. It's like, well, is that the same thing as prohibiting lottery sales across state lines? Or not even lottery sales, mind you, lottery transportation. I'm like, no, that doesn't quite make sense, right? We don't want businesses to enter into agreements with each other that restrain trade because we want to facilitate trade. We want to instill interstate commerce, and you guys are trying to restrict interstate commerce. That's bad. But here we're trying to restrict interstate commerce. It doesn't quite work at all. Yeah. This is old. Is the law the same? Well, the law, whether it's the same or not in this particular domain, I don't know. And it doesn't really matter either way because the foundations of the case are the same, right? So I don't know whether or not the transportation of lottery tickets between states is illegal today or not. I honestly haven't checked. I'm going to go with probably not. It's probably not illegal, but it doesn't really matter either way, whether it's legal or not, because the issue isn't the law in question, right? This is interesting because of its foundational roots. It's interesting because the foundational logic is the same. So whether or not the law continues to exist doesn't really matter because the law could exist because the foundational roots are still in place. That's one of the reasons we cover these cases, right? Not for the law they cover, right? Because whether or not the transportation of lottery tickets across state lines, to some extent, who cares? What we really care about is the foundation of can Congress do it? And if they can do this, what else can they do? And they can do a lot, as this would say, right? And it wouldn't be until Prince versus United States that the Supreme Court would find any limitations on interstate commerce. It wouldn't be for another, Prince I think was it 92? So it wouldn't be for 90 years from here that they would find any limitations for interstate commerce? A lot of states bought in a state you don't reside in are void. That doesn't sound right. That doesn't sound right. It doesn't sound right that if you're visiting a state and you buy a lotto ticket in a state that it's void. That doesn't sound right. You might not be able to cash it in the state you live in, but that it's valid in the state you bought it in. I don't think that's right. No, that doesn't sound right. Let's see what else. Thus, under power to regulate interstate commerce as involved in transportation in original packages of art and spirit from one state to another, Congress, by necessity, effective the Act of 1890, made it impossible to transport such packages to places with prohibitory state and there dispose of their contents by sale, although it had been previously held that art and spirits were recognized articles of commerce, and unless Congress otherwise provided, could have imported into a state and sold the original package despite the will of the state. At the time of the Act of the 1890, all the states had enacted liquor laws prohibiting stale and intoxicant liquors within their respective limits. The Act would have necessarily had the effect to exclude art and spirits altogether from commerce, for no one could ship the goods. You have Hogan on the background every day when you get ready for work. That's pretty cool, Rob. That's pretty cool. And sometimes you get to hear my voice cheerfully from there. Next time I'm on with Richard Hogue, I'll try to break out a little bit of Blackleaf's voice because I know it will please you in the morning. In fact, I'll just do it now. Well, golly gee, Rob, thank you so much for all these wonderful memberships you've been providing to all the chat. Wow, friends, isn't it wonderful that Law and Lumber and Rob have been providing all these wonderful memberships for all you guys who are now the Uncivilians? Well, golly gee, friends, I'm so glad that you all could be here with me tonight. Albus gives me 50 Uncivil Law memberships. Thank you very much, Albus, for your kind super chat contribution. Q Squared is a member for 29 months. Thank you very much, Q Squared. Okay, I need a very brief break. Lumber says, "You little shit." Oh man, I'm glad I could be here with you for that. That's awesome. That's funny. All right, I need a very, very brief break. I'll be right back. And we're back, and we do have some whiskey now. Thank you. You love the sunset lighting scheme? Actually, technically, this is not sunset lighting. You want to see sunset lighting? Let's see. Okay, this is sunset lighting. Today's whiskey is Blue Note Juke Joint Whiskey. Unfiltered, crafted in Memphis. Bourbon whiskey. Uncut. 121 proof. Try to be cautious with that one. All right. Yeah, be cautious with that one. That's a heavy one there. Whew. Like the red under the counter, all the counters are great. Yeah, the colors are great. I do like the various colors. I think they do work out pretty well. All right, let's see where we were. It is said, however, that if in order to suppress lotteries carried on through interstate commerce, Congress may exclude lottery tickets from such commerce. The principle leads necessarily to the conclusion that Congress may arbitrarily exclude from Congress among the states any article, commodity, or thing. Yeah, that is the problem. Of whatever kind or nature or however useful or valuable, which you may choose, no matter what the motive, to declare should not be carried from one state to another. That would be the logical conclusion, yes. It will be time enough to consider the constitutionality of such legislation when we must do so. So they just ignore the problem. It's like, oh, we can deal with that later. There's no limiting principle. Lighting is so fun. Haven't seen a combo you don't like. Yeah, I mean, we do have different kinds of colors and stuff like that. Yeah. The present case does not require the courts to declare the full extent of the power that Congress may exercise in the regulation of commerce among the states. We may, however, repeat in this connection what the court has said: the power of Congress to regulate commerce among the states, although plenary, cannot be deemed arbitrary. Since it is subject to such limitations or restrictions as are prescribed in the Constitution. Which are what exactly when it comes to the regulation of interstate commerce? I mean, not much. So it's not arbitrary because it's subject to limitations. Like what? This power, therefore, may not be exercised to win someone to infringe rights secured or protected by the instrument. But it's a piece of property, and you're prohibiting people from taking it. And there is a under the privileges and immunities, a fundamental right to travel. State to state, no papers. So you have a right to property, and you have a fundamental right to travel, but you don't have a fundamental right to travel with your property. There's some problems in the logic of this decision, it seems to me. Oh, Jennifer, I'm not a moonshine kind of guy. No, I appreciate the thought, but no, I don't like unrefined alcohol like that. I prefer my bourbon, thank you. I appreciate the thought, though. But as often said, the possible abuse of a power is not argument against its existence. Okay. I mean, it's a little bit, right? I mean, and also, why is it abusive, right? You're presupposing, why is it abusive? Yeah. There is probably no governmental power that may not be exercised to the injury of the public. The libertarians would like to hear that one a little bit louder from the back. There's probably no governmental power that may not be exerted to the injury of the public. If what is done by Congress is manifest in excess of powers granted, then upon the courts will rest a duty to adjudicate that its actions neither legal nor binding. Notice, in excess of power, not that is injurious. So Congress has the power to injure as long as it's not in excess of its power, which is logical. So Brian says, my name is Uncivil Law. Yeah, it is. It's right in the channel name, man. What's wrong with that? The whole subject is too important, and the questions suggested by its consideration are too difficult a solution to justify any attempt to lay down a rule for determining in advance the validity of every statute that may be enacted under the Commerce Clause. It's too complicated for us, says the U.S. Supreme Court. Lol. We decide nothing more in the present case than lottery tickets are subject of traffic among those who choose to sell or buy them, that the carriage of such tickets by independent carriers from one state to another is therefore interstate commerce, that under its power to regulate commerce among the several states, Congress, subject to limitations imposed by the Constitution upon the exercise of powers, has plenary authority, which is to say absolute authority is another way of saying plenary, absolute, total, unquestioned authority. And legislation to that end and of that character is not inconsistent with any regulation, so the justice is affirmed. And then there's a dissent from 4 justices, which we will not read. So this has been very, very interesting, to be sure. This has been an interesting series of decisions by the U.S. Supreme Court that we have read on the logic of all that stuff. So I found the logic, they kind of note their own, they note their own logical flaws, and they kind of hope you won't notice. They note their own limitations, like, well, we're going to treat the regulation of morals and the regulation of interstate commerce the same. We're kind of hope you don't notice. And we're also going to say, well, it's been argued that this would allow Congress to do anything they want. Moving on. It's like, yeah, I kind of noticed. I kind of noticed the flaws in your reasoning. I kind of noticed the weak points of your analysis. It wasn't that hard to spot. So all that good stuff. I'm not necessarily in a rush to get... How many pages did it take to get that? Looks like it could have been done on 1 page. Well, a fair amount of it was going through some historical cases to try to prove what Congress has the power to do or not. So there was a lot of history, which is fine, which is fair enough as far as it goes. But then the ultimate stuff is very sort of conclusory in the end. And there's some weak points, and it's kind of like a little bit of hand waving and misdirection, a little bit of magic trick they're hoping that you're noticing you're not going to pull. So that brings us to the end of all that. When did I get different lighting options? Oh, just the other day. It's brand new. I've only had it for I think Sunday. I've only had it for like 3 or 4 days where I had different lighting options, right? Because we used to be doing, do this. This is what we've seen in basically every video we've done up to this point. And it's like, it's a little bit. It's not, I mean, there's nothing wrong with it, of course. It's well lit. It's neutral. It's nothing wrong with it, but it's a little bit samey. It's a little bit beige. A little beige. It's like, I'm getting a little bit tired of the beige. Let's not do beige anymore. Let's do something more fun. Let's try being in the forest. I think we want to be in the forest together, don't you? You and I? Let's be in the forest. So we can have fun with different color schemes. Sunset? We can do sunset. And then I also adjusted the color temperature on the camera to help take a little bit of the redness out of my face, because that was one of the common things, like had too much redness in my face. So I adjusted the color on the camera to help take some of the redness out of my face to fix that. Just trying to make things a little bit better. And then we have the new thumbnails and we have the new everything, man. Things are going great here at Uncivil Law. The camera adjustments just happened like a day ago or so. Like, cause I had the camera settings, I adjusted the white balance like just recently. And I can't change that quick. I have to go up into the camera and change it. So I can't really show you what it looked like before without going in and manually changing the camera. But so it's not as easy as changing the color in the background, where I can just do with a tap of the button. So trying to figure out different ways of making things better and more interesting. I've been watching a lot of YouTube videos on how to make your channel better, right? Think Media, for example, channel I've been watching a lot of, and they have videos on camera settings, and they have videos on lighting, and there's other, of course, channels that do how to make your YouTube channel better, how to fix your mech settings, how to make this better, how to make that better, and so forth and so on. It's like, and so then I get inspiration from them and sort of what things I could try. You know, it's like $150 worth of lighting changes really help to change the set, and then you can do some fun things with it. And then it's like, okay, in terms of how, and then once you get the light strips, it's like, what do you do in terms of the color setup? Well, that's easy, right? That's where you break out the color wheel. All right. That's where you break out the color wheel. And it's like, okay, once we have all this lighting, how do we create colors that look nice to each other? How do we create colors that have nice relationships with one another? No problem. We break out our color wheel and we do colors that have relations to one another, right? Either we pick a color and we pick the colors next to it, in which case it's analogous, or we pick the color and the colors that are in the triangle, in which case it's a triad, or we pick the color and the color across from it, or the colors next to it, in which case it's a split complementary, and so forth and so on. We use a little color theory to make things look nice. And then we come up with results that look like this. Right? Yeah, the tweaks are integrated, make a huge difference. I agree with you, Wish on a Fish. They do. They look nice and stuff like that. And then we have different colors. Like we have different colors and different sims. So you guys have seen Sunset. Sunset is nice. And then like, okay, so we can, for example, we can do, if we want like a really blue theme, we got two different kind of blue theme dominants. We got Ocean. Ocean's cool. And then if we want something even more aggressive, I've got Deep Dive Ocean. Ooh. Deep Dive Ocean, yeah. Really dark blue associations, right? Really dark color schemes. So we got all kinds of weird and fun stuff to make things look fun and interesting. Graphic design knowledge, yeah, it's not really graphic design knowledge just so much as it is looking at the color wheel, right? It's like, okay, I need to create colors in relationships that make sense. You know, colors and that make sense. It's like, so it's like, okay, how do I do that? It's like, I'll just look at colors that do in a relationship, and then I can do things like, okay, I can do violet with analogous colors. I'd like, what would violet and analogous look like? Like, look like that. So the overhead light is violet. The overhead light is violet. The light behind is blue. And the light underline is like magenta or pink or whatever's next to a violet on the color wheel. I'd have to double check. Trufflehound says this green chat is insane. I love it. You're all sweethearts to our friend Kurt. I appreciate it. Thank you. This is making me need to install my fancy lighting setup. Thank you for inspiring me to do it. It's amazing what you can do for not very much. By the way, in case you're curious, the lighting I'm using is Philip Wiz, is the name of it. It's a US brand, I believe. It's similar to Philip Hue. Philip Hue might be the one you're more familiar with. The nice thing about Philips Wiz is, first of all, it's a lot cheaper. And second of all, it doesn't require a centralized hub. It all just talks to my Wi-Fi directly. So it's a little bit simpler technically. And I think the lighting quality is as good, if not better, than the Philips Hue personally. So this is Philips Wiz. So you could get this at Home Depot, right? The lights overhead, right? I got two just bulbs in a pendant light above, right, in the above that you can't see in the shot, but I got two pendant lights that sit above the counter, right, and those can be changed in the color scheme. And then I got just some strip lighting that sits below, and that's easy. And then of course the light in front of me is also Philips Hue or Philips Whiz, right, so I can change that color. And so that color I've shifted so that it's very slightly green, which does two things for me that are nice. First of all, it helps take a little bit of redness out of my face because green contrasts with red. So that's nice. And perhaps even more importantly, it's a lot easier on my eyes because my eyes are sensitive to light. And if I use normal light bulb colors in the light that's illuminating me, right, it makes it harder for me to see. It hurts my eyes. So by making the light ever so slightly green, right, it allows me to have the light on without it hurting my eyes, and so I can film for much longer periods of time without hurting my eyes. And so you just do things like that to find out things that work. And so, it's just some color changing bulbs, and then you set up some patterns, and you put an affiliate link in the description. I think someone said. I did, as a matter of fact, Julia. If you go into my video description, it has links to various things on my Amazon page. It doesn't have a link to the bulbs because those I don't believe are available on Amazon, although I have to double check. But it does have links to basically everything else. And so you can click on the link, and it'll give you a link to the camera I use and to the mounting I use and everything else. So, all those good things. And there is a link to merch, by the way. There is that merch store on Streamlabs. I don't know if any of that merch appeals to anybody, but yeah. Philips Whiz, W-I-Z. W-I-Z. Philips Whiz, W-I-Z. No H. Yeah. So like I can like just even show you the difference. Like, so like the light in front of me, like if I change that to like a daylight color, like the light in front of me, it would look like this. First of all, that's overexposed now, which makes sense because the lighting settings are of course set for a different thing. But you can see like how much the color temperature changes, right? Just by changing the light in front of me to like a normal light color, you can see what it changes, right? So I can change that from 3500 Kelvin, and I can change that instead to this very light green, and then it looks like that. Truffle Hound gives Australian $7.99. This is a much more clear and succinct explanation of color correction to reduce redness than what Elaine subjected us to. Yes, no Amica cream here. It's all just different lighting. It's all just different lighting. And then you just look for the relationships that make sense using color theory. And if you want something green, you can do like a green triadic. It's pretty aggressive, but I kind of like it actually. Right, so you have green overhead, and then purple, orange next to it on the color wheel, or actually in triangle relationship. And also, it's tied to my my Google Home, so I can ask Google to just change the color to something, although I have to ask it for each light individually. How do we get to the merch store via Streamlabs? Yeah, if you just click the link, it should just give you the link to Streamlabs. That's where the merch store is on Streamlabs. So yeah, the merch store should just give you the link if you're interested in any of that. But you can do kind of things like just ask the computer to change things. Okay, Google, change kitchen counter to red.
All right,
It's cool. Okay, Google, change kitchen overhead to pink. Fun. Okay, Google, subscribe to the YouTube channel Uncivil Law.
Sorry, I don't have any information about that.
If I could ask Google to donate money to my channel, I would. That'd be hilarious. A man and his new toys. That Grinch says about how much fun he's having. Yeah, a man and his toys. I mean, it is a toy, and I do like the toy, and I do like the ability to set my toys, and I do like the fact that I have it all set up, and I do like the fact that I can just change from scheme to scheme to scheme, just like by touching a button. It's kick ass. And there's even a romance mode. Any updates with the Lori Vallow case? Yeah, nothing that I'm aware of. The judge had that hearing on whether or not the media was to be excluded or not, but I don't know that the judge has issued a ruling yet, but we do follow it from time to time to find out what's going on and stuff like that. Allegra says, your smile is helping many people's smiles right now. The ripple effect, very much appreciated. Yeah. It's nice when you're happy, and it's genuine. It's genuine, as everyone here can appreciate. It's just genuinely how I feel, and I'm really happy that you're here and help support the channel. I'm really happy to how many new members do we have? 588 new members that we have. That's hilarious. Hopefully some of you guys will continue being members into the future, and I will update the list. I don't think I can do it while I'm streaming. I think I have to wait till I'm doing it. Miranda says I'm going to have to come set up your lights. It's pretty easy, actually, all things considered. Shows and it's contagious in the best way. I'm glad to hear that. And what else can we talk about? I'm just happy to be here with you guys. We should be able to play a game together or some kind. Wait, I don't want to do Jackbox, though. We need to play some sort of different games. I'm not sure what that is, though. Maybe I just need to go to bed. I'm done tired, though. I just don't want to stop streaming. I'm having too much fun hanging out with you guys. I don't want to go to sleep. I want to hang out with my friends. Trivia? Maybe trivia. Pam says you can tell I'm enjoying my new choice. I'm furiously researching Constitution jokes. Yeah, the only Constitution jokes I know are not politically acceptable. Man, yeah. I've told my Constitution jokes before, and it gets me into trouble, man. Law meme review. What's a good source for law memes? Do I just Google law memes, or is there a good Reddit channel for law memes or something? Where do I go for law memes? I'll do some law meme review. Yeah, jury duty? That's cool. Oh, r/law memes? Oh, okay. That's easy enough. Let's take a look. Let's do some Reddit meme review. Yeah, sure enough. All right, let's see if we can make this work. All right. Give me a second to make the margins work. All right. r/law memes on Reddit. Let's give this a shot. See what we got here. All right. Be kind. First cases I painstakingly memorize. The problem scenario which doesn't utilize certain problems of law. Yeah, square peg in a round hole. I mean, 14 Australian dollars from Trufflehound. Found one for Blackleaf. If George Washington, Ben Franklin, James Madison, Alexander Hamilton play L&D, do they roll for Constitution? Nice. Very nice. All right. I think the judge was a bit confused. Man sentenced to death after failed suicide attempt. Task failed successfully. Warning, studying or practicing law can cause serious health damage. Law student posture, law student which is hunched over. True. Law student diet, eating chips. Respect. Law student sleep up at 3 a.m. Doctors. Yeah. I think doctors have it worse. Rise of the plaintiff. Who are you? I'm Ray. Ray who? Ray ipsa loquitur. Wow. Wow, that's a pretty wow, that's and it's a flying barrel. Yeah. Wow, that's pretty hardcore law geekdom right there. Okay. Suspenders. Objection. In the absence of pants, the defendant's suspenders would serve no purpose. Fair. For those following UK news, Dominic Cummings' reasonable law students with a picture of, I think, Sylvester the cat looking like stoned or something, or tired out of his mind. Explain? Okay. All right, so res ipsa loquitur means the thing speaks for itself, literally translates to the thing speaks for itself. And it's this doctrine in law that if something sufficiently bad happens, that the wrongful act is obvious. And the classic example in the textbooks was a case in which a barrel fell out of like the upper story window of like a barn or something and hurt somebody, right? So this barrel just falls out of the window and hurts somebody, right? And they sue. And so the idea was, well, you can't prove negligence because you can't prove how the barrel came to fall out the window. And the answer is res ipsa loquitur. The thing speaks for itself. It's obvious from the thing happening that something went wrong somewhere. We don't have to prove exactly what it is. So her name is Rey in Star Wars. That's her name. And then it says Rey what? And so you see the flying barrel in the panel. Then she just says Rey ipsa loquitur. The thing speaks for itself. Yeah. And also, incidentally, this is just how geeky I am. On Steam, like my Steam name is Res Ipsa Loquitur. And people, of course, when I'm playing multiplayer games, they'll ask, because the Res Ipsa Loquitur, I say, what does your name mean? And I'll just type back the thing speaks for itself. And they're like, well, if you don't want to tell me, you didn't have to be a jerk about it. I'm just thinking to myself, ha 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 ha, suckers. Okay. Tag your law professor. Fellas, if your girl is boring, thick, hard to read, and makes excuses to take your money, that's not your girl. That's the United States Title 26 Federal Internal Revenue Code. Okay. I mean, all right. Keeping it equitable. Equity shall not enforce a gratuitous promise. Equity cannot perfect an imperfect gift. Millery versus Lord, no, I don't think I will. I don't know the case off the top of my hand, but yeah. It's like, yeah, a gratuitous promise is a promise without any compensation. That's what makes it gratuitous. It's something offered for nothing, and you can't get an equitable relief for it. So, no, I don't think I will. Okay. Stupid Louisiana. Imagine using the lame Napoleonic Code. This meme was made by an English common law gang. I appreciate that. Yeah. Louisiana uses the civil law system, which I don't even begin to understand and is probably best ignored. But yeah, unlike the rest of the United States. National Federation of Independent Businesses versus Sibelius. Private insurance market, you can't regulate me. Interstate Commerce Clause, I know, but he can. Taxing power. Okay. How it feels to chew 5 gum. United States versus Satan and his staff. Oh, that's a classic. Civil rights action against Satan and his servants, who allegedly placed deliberate obstacles in Plaintiff's path and caused his downfall, wherein Plaintiff prayed for relief to proceed in forum pauperis. That means for free. The district court held the plaintiff would not be granted leave to proceed in forum pauperis. When the view of the question, personal jurisdiction over defendant, propriety of class action, plaintiff's failure to include instructions for directions as to service of process. Yeah, United States versus Satan and the staff is a classic. Law and Lumber says, you are not defining res ipsa loquitur at midnight. Time to pour a drink, call your friend, and celebrate a happy Wednesday night. Always leave them wanting. You want me to call you? Oh, I can call you if you want to talk on the phone. I don't mind. I'll call my friend Law and Lumber and we can talk on the phone. Okay. All right. I'm down for that. Rob wants to talk on the phone with me. I'm cool. Okay, I'm cool. Well, I'm going to go talk to my friend because he's a cool guy, and you should check him out if you haven't already. You should absolutely check out Law and Lumber, where you can, for example, see Trials in the Century. He's doing some great trials. He's done Patty Hearst, and he did Kitty Gervaisi in New York, classic. He did the McDonald's case, classic. And he does one every Wednesday night, and you should absolutely check out Law and Lumber because he kicks ass. And he's also a very, very nice guy personally, having spent some time with him. And so I like him very much, and you should absolutely check him out. I've been Uncivil Law. Remember to do all the YouTube things, like, comment, subscribe. Until later, my friends, I just hope you have the most fantastic day. Until later, my friends, cheers and goodbye.